you. What is plaintiff's claim in this case?
This is filed as a non-payment of rent claim for possession only. The rent to retain possession pursuant to my client's records is currently $2,257.99. We're seeking court costs in the amount of $170 for a total of $2,427.99.
And ma'am, how are you intending on getting this paid?
I was gonna ask the court for more time. Unfortunately, my employer has been bouncing my checks, and then they just mailed them all out on Friday. So I was gonna ask the court if they can give me more time to pay them.
Well, what I can do is I can adjourn this out a week. During that week, if you're seeking assistance, you would have to file the requisite forms or the necessary forms that came in your packet. That being the rental assistance form, file that with the court within or by Wednesday.
Okay.
But if you're seeking legal assistance, you'd have to do it within that time frame. So I will adjourn this matter out. Regrettably, I do not, counsel, have next week. Is that right? It's the 10th is my next available date. So, and ma'am, you're, just so that you're aware, at that time, plaintiff's claim is going to include your October rent.
Yes, sir.
We'll adjourn it to October 10th, 2025 at 2 p.m. If it is all not paid, ma'am, that is an in-person hearing, so you will need to appear at the courthouse.
Yes, sir.
All right, thank you.
Thank you, Your Honor. You and your staff have a good day.
Thank you, sir. You do the same.
Thanks.
Covington Apartments versus Alicia Bowerbanks.
Morning, Your Honor. Robert Visconti, P61756 for the plaintiff.
Mr. Visconti, she here?
Yes.
Ma'am? Mr. Bowerbank, can you hear me? I see her, but I don't.
She just froze though.
No, she's moving. Ms. Bowerbank, can you hear? I'm not getting a response. I don't know if she can hear me and can't respond. Ms. Bowerbank, I'm going to shut down your video. Let's not do that until I say it, please. Ms. Bowerbank, can you hear me? All right, here's what I'm gonna do, counsel. Let me pass the matter and let's see if we can get a message through to her.
It looks like she just sent a chat message saying, yes, she's here.
Right, but Ms. Bowerbank, if you can hear me, can you wave your hand? Okay, she can hear me. All right. So we can't hear you, but what is the plaintiff's claim in this case?
Your Honor, this is a termination of tenancy based on a health hazard. My client, on an inspection of the unit, observed that ingress and egress was blocked due to what they termed as clutter throughout the unit from floor to ceiling. They requested that it be remediated. Upon a subsequent inspection, it had not been.
Got it. Okay. Ms. Bowerbank, we're not going to be able to do much. Ms. Bowerbank, if you would like to be represented by counsel regarding these claims or get an attorney, you can call legal services to assist you. Okay. Or you can call the Michigan Clinical Law Program. All right. What I will do, Ms. Bowerbank, is I will adjourn this out 1 week for you to be able to do that or make your decision regarding that. I will, well, and it'd actually be 2 weeks. It'd be October 10th, my next available date, 2025 at 2 p.m. Okay, that's an in-person hearing, and you'll have to appear at the courthouse on that date. Okay. Ms. Bowerbank, if you understood all of that, can you wave your hand for me? Okay, she waved her hand. Okay, thank you.
Thanks, Judge.
You're all set. We'll see you in a couple weeks.
Have a good day, Your Honor.
All right, thank you, Mr. Scanlon. HP Foreclosure Solutions versus Jeffrey Bogdan and Deborah Bogdan.
Good morning, Your Honor. Adam Devlin, P 72877 for the plaintiff.
Is that on this case?
Yes, she indicated she was.
Yes, sir.
All right, your name, ma'am?
Mary Cheatham.
Okay, you're gonna have to speak up or for all of this.
I'm sorry. Mary Cheatham. I don't.
Okay. And ma'am, what is your relationship to this case?
I am the daughter of Jeffrey and Deborah Bogdan. They are both deceased. Your Honor.
Okay, all righty. And this is a termination. The basis for the termination is a foreclosure.
Yes, Your Honor, failure to inspect.
There
All
was
right.
actually an inspection done on August 11th by Michelle, who works at HP Foreclosures. And I understand that it was late. I don't know. It's really a long story. My mother passed away in January. There's just been like a series of unfortunate events. And I actually have a probate hearing on Monday at 1:30, where I'm hoping, because I was appointed as the executor in her will, and I'm hoping to get that appointment letter. I just really am asking for like the full redemption period. I was incarcerated. I was just recently released. My mother passed while I was incarcerated. I'm just trying to get all this stuff figured out. I realize my time is dwindling down. I'm just asking for the time that I'm allotted for the redemption period in order to do that.
Your Honor,
Okay, so-
if
Go
we've
ahead.
inspected, I lose subject matter jurisdiction to be here. My client did not inform
Right.
me that they inspected. It asked to be thrown in a breakout room with her and have the pretrial adjourned 2 weeks with the understanding that I'm probably going to dismiss.
Okay. I typically don't do breakout rooms, but under these circumstances, I
I just
May
need to get
make
her
an
contact
exception.
information, Your Honor.
all right. So ma'am,
Yes,
here's
sir.
what I'm going to do is I'm going to adjourn this out to October 10th, 2025
Okay.
at 2 p.m. Okay,
Okay.
that's an in-person hearing, ma'am.
Okay.
But what it sounds like, so that, I mean, seems to me you got a lot going on. You've indicated that there was an inspection, so that
Correct.
may, I'll put it this way, potentially divest the court of jurisdiction to hear the matter, depending on the timing of things and whatever and the like.
Okay.
So I think what counsel wants to do is he wants me to put you into a breakout room so we can get contact information, so we can check out what you've said.
Okay.
Okay, do you have any problem with that?
No, sir.
All right, fantastic. Then
All right.
what I will do is I'll adjourn it to the 10th at 2, I think I said. At 2 p.m., that's an in-person hearing, and I'll put you two into a breakout room. All
Thank you.
right, thank you,
Thank you.
folks. Arbor Manor Townhomes versus Diona Allen.
Thank you and good morning, Your Honor. Paul Huth, P 31986, appearing on behalf of the plaintiff.
Diona Allen,
I believe she's in the Zoom room. I see the name.
Hi, I'm here. I'm just trying to turn on my camera. I'm sorry.
all right, while you do that, Mr. Hughes, what is your claim?
Thank you, Your Honor. This is a non-payment possession only case. The amount of rent due is $3,402, court cost of $172, for a total amount due of $3,574. The last payment
All right,
in this case was back in March.
gotcha.
Current rent is
All right,
$69.
okay, thank you, sir. And ma'am, how are you intending on getting that paid?
I applied for SCR. I have been approved. I have a phone interview on Monday. I can also put a payment down about $700-800 on Tuesday, and a couple more hundred on Friday as well. So I'm hoping that they can help me with majority of it.
Are you
But
talking SCR?
Yep, and I sent the office my application as well.
All right, so there's a couple things going on here. You need to pay the 700 or 800 or what you can pay. All right.
Okay.
And what I'm going to indicate, you're going to get that, the 7, 8 plus maybe a couple hundred, and that you're going to do that by the by the 3rd
Yes.
of October.
Yes.
Okay. If you apply for an SER, you'll also need, in your packet, there was a rental assistance form.
Yep.
You'll need to fill that.
I filled that out as well.
Okay. Have you submitted it to the court?
Yes.
I don't have it. Make sure that it is submitted to the court. Actually, I think it's here.
Yeah.
Okay, I've received a rental assistance form, it looks like.
Okay.
However, I don't have you're gonna need to redo it because you have to put the tracking number on it of your SER.
Okay. I can do that.
And the other thing is, how many people are in your household?
It is me, and then I have 3 other children.
Okay, so you have a total of 4. Just so
Yes.
that you know, the maximum you're gonna get under an SER is $740, and that's typically gonna have to be paid before they're gonna pay. So just so
Okay.
you know, they're not going to cover the amounts here. All right?
Okay.
With all of that, I'll adjourn it to my next date of October 10th, 2025
Your Honor,
at 1 p.m.
Judge,
Yes, Mr.
I have a conflict on that date. I didn't think it was going to go 2 weeks out. Could we do the 24th? That's my,
I have that, right?
Yes.
Okay, I'll adjourn it to October 24th, 2025 time at 2 p.m.
thank you, Judge.
Ma'am, you're
Yes.
welcome. Ma'am, that is an in-person hearing, so you'll need to appear at the courthouse.
Okay. Thank you, Your Honor.
Thank you. Arbor Manor versus Sharia Patilo.
Thank you. Good morning, Your Honor. Paul Hughes, P31986, appearing on behalf of the plaintiff.
Hello?
Hello.
Hello. All right, what is plaintiff's claim?
This is a non-payment possession only case. The amount of rent due is $2,224.06, $172 in court costs. Total amount due $2,396.06.
All right. Ma'am, how are you intending on getting that paid?
My grandfather is gonna give me the money. I just have to wait until he gets paid because I lost my job due to having seizures and the medicine that I was put on. I can't work. So he was gonna be financially responsible for me as far as to pay off.
All right, when is he intending on doing that? Do you know?
He told me that he needed about 2 weeks. I don't really know if it's possible to get that.
All right, so what I'm gonna do is I'm gonna indicate that you're gonna pay the balance, I'm presuming, and your October rent by the
Yes,
10th?
sir. Yes, sir.
All right, and given Mr. Hughes' schedule, I'll adjourn this out to October 24th, 2025 at 2 p.m.
Thank you, Judge.
Okay.
All right, if you
Thank
get
you.
everything paid, ma'am, if you get everything paid, then it's likely they're gonna dismiss this. But
Okay.
everything needs to be paid. You gotta make sure everything is paid. Otherwise, you gotta be here at the courthouse.
Okay.
All right, thank you.
Thank you. Have a blessed one.
You do the same. Arbor Manor versus Felice Wilson.
Good morning, Paul Hughes, P31986, appearing on behalf of the plaintiff.
All right. Miss Wilson is here present in the courthouse. Okay.
Can
No,
I
you can
get-
stand right up at the podium, ma'am. See that there?
I have
Okay.
something for you.
Hold on. What's your name?
My name is Felice Wilson. Good morning.
All right, thank you. What are you trying to give me?
This was a printout statement of the payments that I made and the misunderstanding of them going up on my rent and why I have a balance. So I got the printout from the bank and from
From the bank?
and from them, the ledger. It's just a 12-month ledger from both parties. It was my rent been on time forever. And there was a jump in $500 and they kept telling me that they would change the rent. And I was waiting for them to respond. So it was just.
Was that a recertification issue?
I gave you that because that's the only thing I had when I came to write the letter. I gave you a copy of the recertification and they said I would be due in March. They reprobated, I guess, my rent and gave me up until March to pay off whatever I owe.
Stop for a moment.
I'm sorry.
What is plaintiff's claim in this case?
Thank you, Your Honor. The amount of rent due is $3,075, $172 in court costs, for a total amount due of $3,247. It looks like her current rent is $422, and that's down from $825 in June.
Okay. First of all, do you agree that your rent is $422?
As of now, yes, sir.
As of now?
Yes, sir.
All right. And you're basically indicating that you have paperwork that you've made all of the payments. So how much are you paying per month?
I'm sorry. So I do pay the $422. My rent was $170 every month and I would pay $200. In April, they recertified me. She said it would go up to $325. And then I started getting stuff on my door saying it was $825. When I went to tell her, I can't afford that. It doesn't equal out 30% of my income. She kept telling me she would change it. Wait till we contact you. And every week I would get, it was just adding up and they never changed it. So I would pay what I could. And in June, when the court put the paper on my door, I just stayed at the office until someone talked to me. They sat there and they adjusted it to the $422. I asked if they were going to readjust what the proper payment would be for my reassignment. And she said that you have to pay the $2,000 off. I just feel as though from $170 for a year and a half.
I hear you.
So I just got the statement. You can see that I paid on time.
Are you going to have an attorney represent you on this, or are you going to represent?
I've never been in this kind of situation. I just don't want an eviction. It's scaring me and I'm trying to fix what's going on. I trusted that the office told me not to worry about it.
Ma'am.
So,
you have the right to have an attorney. You
Okay.
can contact legal services regarding that. If that is something that you'd like to file with the court, you may, but you'll have to send a copy to the plaintiff's attorney. All right, if that's the ledger. So you can file that certainly at the counter with the court and do that, and we can deal with that.
Okay.
I'm going to suggest that you contact legal services and we can make sure that you have the phone number to do that. I'm going to adjourn this out, given the court schedule, Mr. Hughes' schedule. I'll adjourn it to October 24th, 2025 at 2 p.m. Okay, and go ahead. What were you going to say?
I just had a question. So I am paying what they asked for as of now. I've been paying extra to pay down. Do I continue to do that for next month?
I'd certainly continue to pay it. The worst that can happen is that you'll ultimately end up with a credit if that amount wasn't due. I mean, that's the worst thing that's going to happen to you.
Okay.
But if the money is deemed to be owed, then at least you chipped away at what the amount would be.
I understand.
Okay?
Yeah.
All right. Thank you.
And certainly go talk to your landlord and go over it with them and they'll explain exactly what the issue is.
All right. Ma'am, Mr. Hughes was saying, go also to the rental office, explain your circumstance again, and have them go over the ledger with you so that everybody can maybe be clear by the time we get here on the 24th.
No problem.
All right, thank you.
Thank you, Judge. Have a good weekend.
You do the same, Mr. Hughes. Court does call the case of Sio Farms versus Holly Connelly or Connelly today.
Good morning, Your Honor. Casey Matson, P87729 on behalf of plaintiff.
Right. Are they here?
No.
They have not checked in. If you'd like to take a default, you may raise your right hand. Hello, what's your name, ma'am?
Holly Conley.
Okay, she's here. We've got you. Okay. What is plaintiff's claim in this case?
Your Honor, I have rent to retain of $2,287.06. Court costs of $190.00 for a total of $2,477.06.
And ma'am, how are you intending on getting that paid?
My ex-husband is supposed to cut a check, and we're in the process of hopefully transferring this over into our children's names. I have recently lost
I'm
my.
sorry, you got to stay right near your microphone because you're moving in and out. Say that again to me.
My ex-husband is supposed to be paying for it. We talked to him last week and he said he could do it. The problem is he's in Washington, and so his hours are funky and it's hard to get a hold of him. But he said he'd pay it because we're in the process of transferring this over to my children because I'm going on disability and can't afford it anymore because the rent goes up every year. And so we're gonna see if we can't transfer it over to my children.
All right.
The process of all that, but as far as being able
So
to get the
he's
whole.
gonna, so your understanding is he's gonna pay the entire balance, but you're not
Yes.
sure when that's gonna happen?
He's supposed to pay the entire balance within like the next 10 days. But
Okay,
and then he's gonna buy the trailer from me and I'm going to leave and we're gonna turn everything over to my kids and go to
gotcha. Okay.
the.
So here's
Sign
what I'm
off.
gonna do, and here's what I'm gonna do in terms of the payment. I'm going to adjourn this matter out to my next available date, which is October 10th, 2025 at 3 p.m. That's an in-person hearing. If what
Okay.
you're indicating is correct, and I don't have a reason to doubt it, he should have paid everything off by that point in time.
Yes, he should have, yep. And then he's gonna pay
Okay.
the as well, so October will be covered too.
Okay.
Okay,
So very good. Then we'll do that. That's an in-person hearing. So if everything is not paid, you need to come down to the courthouse.
all right, and if everything's paid, then we're good to go?
Pardon?
If everything's paid, then the court's canceled and we can go ahead and sell the trailer over to my kids and have my kids fill out the paperwork for the here, right? In other words, if he pays, I don't come to court, right?
Pay that at the court?
If he pays the whole entire bill, I don't come to court. Correct?
You do not have to come to court if everything is paid off.
Got it. Thank you.
Thank you.
All right, I have Jameisha Butler, 2 cases, 25 CR 3233.
She's probably looking out for this. I was unsure before we have the document.
What's on your shoulder?
Take it.
What is that on your shoulder? It's a device, huh? What do you do over there?
Process operator.
Process operator. Okay, let's see. This looks like an analysis on 2 cases. As you know, these are (32 and 33). Just 1 second.
Okay. This one. Sure. You're good.
Looks like the same event.
Yes, yes, sir. Same transaction.
Okay, well, this is an announcement, and you understand you were charged here with a 3rd-degree felony of evading detention. And apparently it alleges that the complainant in this case suffered serious bodily injury. So it's a third-degree felony, which carries with it up to 10 years in prison. The other one's not any better, but much worse, escape, which is a first-degree felony, the way it is alleged, which carries with it no less than 5, no more than 99 years confinement or life imprisonment. And fines up to $10,000 can also be assessed in each of these. Okay, these were both handed up on January 15th of this year. What are we going to do?
Judge, I've been speaking with the state throughout the last vote. We've had some communication issues, but I think we've resolved those. We're trying to get matters resolved. There was a discovery issue that we got resolved last week, so we're talking. It's the best way I can describe it. This.
Okay, that doesn't help me. I move forward, and that's once again, it'll be October next week, and this one hasn't been rolling around since the beginning of the year. So, how much time do you need for a decision?
It's always part of it was based on the conversation.
I'm gonna give you 3 weeks.
Can we have a month, Judge?
I think we'll be able to discuss it next week.
I heard a whisper over there.
You've got a gap. I believe it's 3 weeks.
Did I know about that?
Yeah.
Or did y'all have some kind of a sinister plan afoot? 4 weeks, good. Okay.
Yes, sir.
Yes, sir.
Oh, thank you.
Francisco Torres is Ryan Gertz. Francisco Torres, are you here? That you? Okay. Have you talked to your attorney today?
No.
Okay.
He's running late. He'll be here.
Just confirm.
That's a false statement. He is not running late. I've never seen Ryan run. I'm not sure he can run, but because I know him from way back. Carly Fowler. Carly Fowler once.
She might be in federal custody. This was a dismissal.
Carly Fowler twice.
I think she might be in the back, Your Honor. She's in custody.
And they said, is there a dismissal on the tablet?
Yes, I have to hand it over to you. Oh, sorry.
Thank
you. She'd been in federal custody.
Who wants to dismiss on this?
Well, I know.
That's a no. Thank you. He who hesitates is lost, right? Can I talk you into it?
I'm gonna say yes.
Yeah, I did. You want one? I got 2 of them. Okay, Carly Fowler, is that you?
Yes, sir.
24 CR 1990. You were charged with the first-degree felony of aggravated robbery, which carries with it up to life in prison. I'm about to dismiss this case.
Really?
Does that make you feel better?
For real? Oh, that's so great.
Well,
thank
only because it's apparently the right thing to do.
Thank you.
The question is, how did you get I don't want an answer, but how do you get yourself into something like this, And I think, have you learned a lesson out of this whole scenario? Valuable lessons that you will use in the future in making judgments. Okay. I'm sorry, I didn't ask you. Was this okay with you?
I'm going to say yes, Your Honor.
Is that your final answer?
That's my final answer. I'm ready to call us teammates.
The case is dismissed. I mean, it's obviously a serious matter, and I don't know how you got into this, but you're getting out of it. But hopefully, it made you a wiser person in the way of decision making. Okay, that's done.
Thank you, Your Honor.
Taylor Jackson. I think that's yours too. Is that right? Yeah. Two cases. I don't see dismissals on these.
No, sir, Your Honor. We are, Ms. Sarah was the prosecutor. Last night we were here, the court was giving me an opportunity to go unseal the certified juvenile records. I've been in touch with Mr. Nelson. I really need to file a motion for that. There were loose standards. And so I'm respectfully requesting one more.
He's got 6 cases total.
I have 4 in mind.
Just 4?
Yes, please.
Anyway.
2 incidents of complaining witness.
You might not have a new one.
Is there a new one?
All right, I have 2260, 2261, 2262. And in sequence 2263.
25.
Not with.
Oh, yes, it's a UUMV. He is a state jail.
That's right. That's official.
007.
It's not.
Might just be out of order. If not, I'll print it out.
Still using a numerical sequence method on.
Yes, there we go.
I forgot about the Cajun. It's not important in my office, though.
Taylor. Taylor. Hey, Ellie. Thank you. Because I think I fixed the problem here. Need 5. 2260 61 62 63 and 77.
I believe 77 is the new one.
Which is unauthorized use of a motor vehicle.
Correct,
Okay.
yes.
Yeah, it was in here.
Okay.
It was just. Okay. These are all. Hear me? Oh. It doesn't get much more serious than this.
Yes, sir.
And these are 4 aggravated sexual assaults of it looks like 4 charges involving 2 separate children.
Yes, all juveniles, sir,
Is that right?
Yes, Your Honor.
including the defendant.
And then the other one is unauthorized use of an oil vehicle, which I guess is state jail felony. It is. So what did you say?
Your Honor, last time we were here, the court was allowing me a reset to try and go ahead and get the certification records because our client was a juvenile at the time of this. I did attempt to get those records. That was blocked by the district clerk's office. I talked with Mr. Nelson. Mr. Nelson has advised me that, of course, I don't think there can be an opposition, but he would not be opposed for me to file a motion to unseal the certified certification procedure in this particular case. Along with that, I had some attempts to reach with Sarah, but my mother-in-law went in the hospital, came out of the hospital and got COVID from the hospital. So it's been a little dicey for me since that time. I'm respectfully requesting another continuance announcement to go ahead and do the unseal and to get with Sarah, although I think in this case may be transferred to another ADA.
Stand by. All right, looking at the dates of all this will be.
Yes, Your Honor.
These were two children, 8 and 11 years of age. And then the defendant looks like he was 15.
He ranged from 13 to 16 in the offense states. The children ranged from 7 to 8 in the offense states.
The defendant's birthday is in May of 2003.
Correct.
So December 11th of 18 would have been 15. And he would have been 15 in 262, December 11th, 2019, he would have been 16.
Yes, I think there are some offenses that are not alleged in the indictment. But
Well, I'm there, I guess.
right.
And then 2263, December 14th, 2019, 16 then. And then Group 6-2 is 15. Okay. On 2 instances, he was 16 and 2, he was 15.
I believe so, Your Honor.
All right, and there's not an issue about age on the unauthorized. He was an adult during the unauthorized use of a motor vehicle.
Yes, sure.
These were all indicted October of last year, right?
Correct, Your Honor. I believe he had a different defense attorney for quite a while.
All right. And these are all first degree felonies, which would generally carry with it up to life in prison in each case. And then the unauthorized use of a motor vehicle is up to 2 years in the state jail. Today, what do you want to do?
Yeah, I'm respectfully requesting one more announcement.
How much time?
Would the court allow me 60 days in this to get to deal with the sealed records, which I didn't anticipate a block from the district clerk like I got, but at the end of the day,
I'll give you 6 weeks. Let's see where we are then. Okay. 6 weeks. Let's try to meet it at 6.
Yes, sir. Thank you, Your Honor.
I'll give you a reasonable amount of time.
Yes, sir.
Brian, is the issue for me to get here?
Arnie Koenig. I'll be fine. Okay, you're Mr. Koenig?
Yes, sir.
And Mr. Lane is here. You were charged here in 24 CR 2327 burglary of a building, which is a state jail felony. However, the indictment also alleges you have 2 prior state jail convictions, one out of Liberty County in 2017 and another out of Liberty County in 2021, which does that enhance this to a 3rd-degree felony?
Yes, sir.
That's correct, Judge.
So you're looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. If these felonies are accurately alleged, you are not eligible for probation in front of a jury. So it's all or nothing. In front of a jury.
Yes, sir.
What are you going to do today?
Your Honor, I've not had a chance really to talk with the state's attorney. Last time we were here was our first announcement. We do have discovery in this case. I've gone over with Mr. Connelly, but if the court would just allow me one more announcement, I could talk with the state's attorney and see where we're headed.
Actually, this was the 5th announcement.
Really?
Oh, yeah. We have one here that was on February 4th. And then the next one is on May 19th. And the next one is August 5th.
Oh, well.
And then August 7th, something must have happened where you asked for some additional time.
Yes, sir.
And then August 13th. And then here we are today in September. So I mean, we've been, the announcements began in February. So
I think I apologize.
Okay.
Last time.
What can you do about it?
I was here. 30 days.
Yeah, 4 weeks.
Thank you.
4 weeks. Okay. Where are we on that? Is there something working?
Your Honor, there was an offer made by Daniel who had this case before me. At this point, the offer remains the same. We can discuss what that is.
Hey guys, no texting. I'm just kidding you. Don't get that. We're texting each other. I'm just texting each other. Can I get in that loop?
Right, thank you, Your Honor.
I just like it. Those guys are working on things. You know, they got everybody's got schedules. That's like that because everybody's busy.
Yeah. Yes, sir.
So 4 weeks good?
Yes, sir.
On it? Okay, Brian. Thank you. I've got Darren Porter. Hey, Brian. Darren Porter is next. Thank you. And then Brandon Richards after that, and then you're done.
Yes, sir.
By the way, I've got a Kevin Bond dismissal before the court. So I'm signing that, whoever's on that one. Thank you.
I see 25 to lot.
That's been
Okay.
Minutes. One. Oh, no. That is my.
Okay, that one, Carlo Fowler, that's both been dismissed. On Darren Porter, that's you, sir?
Yes, sir.
25 CR 335, you're charged with a 2nd-degree felony of burglary of a habitation, but it doesn't end there, as you know. You've got 2 prior convictions that are alleged, which are serious. One is a second-degree felony burglary in 89 out of the court next door. 252nd, then also out of the 252nd after that conviction in 1989 of burglary of a building was final. It was in the old days when they
On CR 38763, present before the court is Ms. Newland, right?
Yes, sir.
We have Mr. View from the prosecutor's office, Officer Fisher from probation. We're here today, Ms. Newland, because I've received a report that alleges you have violated the terms of your supervision. The allegation is that you picked up 2 new theft offenses, one in Greene County in June of 25, one in Montgomery County in August of 25. You have the right to be represented by a lawyer in this case. If you can't afford one, I will appoint a lawyer for you. Do you want to be represented by a lawyer?
Yes,
All right, are you going to hire a lawyer or do you want one appointed?
one appointed.
All right, in anticipation of this request, Mr. Harden is here on an unrelated matter. So what I'm going to do is have you complete the affidavit of indigency. I'm going to appoint Mr. Harden to represent you, and then you can talk to him while you're here today. And then you and he can let me know whether you want to go forward today or whether we want to come back a different time.
Yes, sir.
Okay? All right, Mr. Harden, thank you for being available.
My pleasure, Your Honor.
And then
So I don't have an issue with that, Your Honor.
I mean, everything's status quo, same as it has been.
it wasn't a state jail felony. It was a second-degree felony in the old day. Then the defendant is alleged to have committed assault of a child and convicted in that court in 2005. So what we have here is habitual felon status. You're looking at no less than 25 years to life imprisonment. Do you understand? Serious, as serious as it gets next to capital cases. All right. It's been around a while. What are we going to do? And again, here, this is one of those where you're not eligible for probation in front of a jury if you went to trial. So it's pretty much all or nothing there in front of a jury. Okay. Yeah, we've been getting resetting since May. So what are we going to do?
We've been made an offer from the state. We will respectfully ask that this be placed on the trial.
It's set for trial. And how long can everybody be ready?
We have a new status, Judge.
We're going to put this quickly. Okay.
Thank you.
Set for trial. And please get ready. Brandon Richards. And on this one as well, we go way back on announcements. What are you going to do on this one? It's a Fisher cut bait day.
Yes, sir. Well, we'll respectfully placing this on the trial docket.
Okay. You're looking at up to 10 years in prison. Does he have prior? You know? No, I don't think so. Okay. Gonzalo Alvarado. Gonzalo Alvarado, please.
Okay. Morning, Judge. Rather, this is my full ex parte motion. Mr. Here is the prosecutor on this case. I don't know.
Yes. You're retained on this though, right?
That is correct.
Well,
If you read the top that he just filed.
hmm.
You filed something this morning. I have it on top for you to peruse.
The judge, again, assistance in ex parte.
No, I understand.
Thank you.
Is that all we're doing today, dealing with this?
This is it, Judge.
Okay, stand by. Let me get the other stuff and then we'll.
Yes, sir.
Yes, sir.
Thank you.
And Sabra Shivers, or Shivers.
Shivers.
And Mr. Gasper is. Do you have an attorney, Gasper?
What?
Is Mr. Gasper your attorney?
I'm not sure.
Oh, that's the state's attorney. Oh, it's kind of.
She's not here. Miss
Is anybody here for the state otherwise?
She's right there.
Saber?
She's here.
Oh, thank you. The NTRP status review, right?
I believe so, yes.
I reached out to her.
So she's not here?
Don't.
Saber? Sabra Adriana Shivers. Sabra Adriana Shivers or Shivers. There is no answer in the courtroom. I ask the bailiff to call into the hall for Sabra Adriana Shivers. Please.
Please.
I sense something's amiss. When was the last time, has she failed to report? Really? Is she new to be here?
I reached out to her yesterday. No response, Sean. She didn't answer the phone. I contacted police forces. They did not answer either. She did respond to an email that I received this morning, stating that she had a new phone number and that she was not aware of the court taking the order.
Well, she's aware. Who said she's not aware of the court date?
She said she was.
When did she say that?
I received an email this morning.
Oh, but she's aware. How could she not be aware? She's telling you she wasn't aware, which means she's now aware of it, right? Okay, well, she didn't appear.
I'm no longer.
A warrant is issued for her arrest. That's all we can do. She's on regular probation. That's a conviction, and a warrant shall be issued for her arrest.
Released her without warnings.
I got a warrant for him. And looks like we had a hearing back in 2024 about failing to report. I found true and then continued her on probation. Then the new failings to reports and then showing drugs in her system and not reporting the new address.
About 6 weeks ago, she came in and she said that the reason that the drugs were in her system was because she was struggling with domestic violence, and then said that she did have a drug patch and could be continued on probation. I have not seen her since then, but she isn't scheduled until the 7th of next month.
Well, she needs to, we don't have supervision of her when she's doesn't show up. She's gonna do her part. And she fails to show, and she did know about this, correct? Well, when she's arrested, then we'll deal with it, I guess is all we can do. Because those are all serious things that we need to keep updated with. Because there's no excuse for methamphetamine in your system.
Do you want me to tell them the meeting to include the violation?
No, man. I don't think it's necessary. You know, I think she's got enough problems right now. Okay. Yeah, I did.
Okay.
And LaDonna Lewis. Want to get it? 24 CR 101. Open. Look, those are that a little letter of support.
And letter of support.
This is Sentencing Road, right?
Yes.
Is that what it is? Something. Hold on, let's get put the file. Okay, we're calling 24 CO 101, the state of Texas versus LaDonna Renee Lewis, which is you, ma'am. And you were here with your attorney, Mr. Nayland, and the state's attorney. I'm looking at this first letter of support from Adorio Dorsey. Who is that?
She was a coworker.
It was a very nice letter. I mean, truly, it's this person writes very well and got the point across and thinks very highly of you. And then here's another one from, it looks like, is it Teresa Robinson? I think the T is marked out. And that's a very nice letter as well, written on your behalf. How do you know this person?
She's my current supervisor.
Your current supervisor. Which my current supervisor would write me a nice letter. My wife. Once. Marcy thinks I'm doing well. She said, needs work.
Yeah.
Needs work, but yeah, I'm doing well. This her.
It's improving.
I'm getting better, she said. Oh. Okay, earlier here, the defendant pleaded, well, it's not showing. Has she already entered a plea?
Yes.
Okay. This is not showing on the file. Entered a plea guilty to misapplication of third-degree felony of fiduciary or financial property. And the agreement is that
Ms. Newell, you can sit down, you're fine.
Did you want to approach?
You can sit down, you're fine.
I did, Your Honor.
Okay. Do you want to go forward with the hearing? Is she admitting to the violation? What are we doing?
Sorry, Your Honor, but yes, I've discussed it with her. She's admitting the violation. They did result in 2 convictions. We've advised the court of, and I'm sure the court was already aware, 9 months on the first one out of Greene County. Montgomery County gave her a 6 months sentence concurrent. Her expected out date is March. She's enrolled in a program. I know this goes more into mitigation, but she is admitting the allegations. She's currently enrolled in a program for drug offenders and drug addiction. It's inpatient. It's through Marysville. She doesn't know the anticipated out date, but I'm guessing it would dovetail kind of with March.
All right, Ms. Newland, do you understand the rights you're giving up by admitting to this violation?
Yes.
Is this what you want to do?
Yes.
Do you admit or do you deny that you violated the terms of your supervision?
Yes.
Based upon your admission, I find you have violated the terms of your supervision. Mr. View, anything from the state?
Nothing additional, Your Honor. Thank
Officer
you.
Fisher?
Nothing further, Your Honor.
49 days of jail time credits on right to everybody?
Yes, sir.
I was told it was 62 days.
Well, we can recalculate that. So Officer Fisher, if you would go ahead and recalculate that. Not right now. Recalculate it, send me an email. We'll take a look at that. Every day that you've done just on this case, you get credit for. Anything else you want to tell me?
No, sir.
My directive to you, Ms. Newland, was pretty clear. Don't steal. And you picked up 2 felony thefts while you were on probation with me. I find you are not amenable to community control. I'm going to sentence you to 10 months in prison. I think that a consecutive sentence is necessary to properly punish you. More importantly, to protect the public. The overall sentence is not disproportionate to the conduct involved here or the danger posed by you. I'm going to give you credit for the 49 days that you have already done. Check with the people at the Bureau of Computation when you return to the prison, Ms. Newland, and they can help you do the math on jail days. I do want to make sure that you get credit for all of the days that you have in. All right, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, it will all be provided to you at no charge. Good luck to you. Do you need time to review the documents with Ms. Edwards? Okay, well, let's take a break then.
Defendant would be placed on probation of a type and length at the court's discretion, and restitution in the amount of $8,966.09 would be part of the order of probation.
Yes, she paid back a big chunk. That's just what's left over.
Is that right?
Yes.
What is the balance?
That's about 8,000 the balance. She paid off about 24,000. It was 37,000 total.
Oh, okay.
But that's the balance of it right now.
So the balance is still $8,966.
Correct. Yes, we were trying to get that done before we finished the case.
Okay. How do you have a plan? What is your plan on getting that paid back? Because that's what's in, the quicker you pay it back, the quicker you get rewarded.
Yeah, but plan is like
How is that going to be done in your plan, though? Do you have like a monthly plan?
Yes, sir.
About how much?
At least 300 a month.
Can you do that?
Yes, sir.
Because I'm going to order at least 300. All right. The parties had an opportunity to review the report. Are there any corrections or changes to it or comments? First of all, defense.
No.
Okay, state.
Judge, there is a memo that was added on from the complaining, one of the officers of the association, huh? Yeah, just got it. So it should be, I don't know if it's in there or not.
It's not.
And Judge, I wouldn't add to that letter being part of the PSI. I think we were going to address that, but since I'm talking about Huseby State says that a layperson shouldn't be giving, shouldn't give testimony on the position for punishment. Also, he was a member of the same association she was. I think I'm sure he's mad, but and so it actually doesn't really matter on our plea bargain anyways, but I'm just making that objection to the record that it's an improper part of the PSI.
What's the state saying on it?
Judge, this was an interested party, one of the people that belonged to the association that she stole from. So be like a complaining witness that is voicing their opinion about the plea bargain agreement and as well as the way it affected the members of the organization that she took from and the trust that they placed in her before she took this money.
What's the organization here? The sheriff's?
The sheriff's, yes, sir.
So a non-governmental entity made up of governmental entities.
Jefferson County Sheriff's Association.
Yes, sir.
Oh, it says Huseby State 787 Southwest Second, 193.
Officer Martinez, do you have the registry paperwork?
Yes.
All right, this is the case of the state of Ohio versus Denisha Edwards. Case number 25 CR 42649. Present before the court is Ms. Edwards, right? You're Ms. Edwards, right?
Yeah.
Represented by Mr. Engel. We have Mr. View from the prosecutor's office, Officer Martinez from probation, Ms. Kennard from the victim's advocate's office. We are here today for sentencing. So everybody had the opportunity to review the PSI.
Yes, Your Honor. Yes, Your Honor.
Any reason not to go forward with sentence today?
No, Your Honor.
All right, a couple of housekeeping matters. We do have the notice of duties to enroll as a violent offender. I have a white copy here of this, Ms. Edwards, that indicates your requirements under the duty to notify and to enroll as a violent offender. Did you read that over with Officer Martinez? Did you read that over with Officer Martinez?
Yes, sir.
Is that your signature at the bottom?
Yes, sir.
Do you feel like you understand the contents of that document, or do you want me to read it to you?
I understand it.
Okay. Second housekeeping matter, we have two exhibits to the sentencing entry. The first is a notification regarding indefinite term of the Reagan-Tokes. That means that you're going to receive an indefinite sentence here today. It's presumed that the Department of Rehabilitation and Corrections will release you at the minimum term, but they can, under certain circumstances, keep you up to the maximum prison term. Your rights, responsibilities under that. This is a notification regarding your indefinite term, Reagan-Tokes. Did you look that over with Mr. Engel?
Mm-hmm.
Do you understand that, or do you want me to read it to you?
I understand it.
And then also we have Court's Exhibit number 2, notification regarding post-release control, which is an advisement on your rights regarding post-release control. This carries with it a mandatory period of anywhere from 2 to 5 years. No, 18 months to 3 years, right? 2?
They're all second-degree felonies, Judge.
I'm sorry?
They are, all three of the offenses are second-degree.
Yeah, so it's 18 months to 3 years. That means the adult parole authority is going to supervise you. If you violate the terms of that supervision, you can be returned to prison. Do you want me to read that to you, or are you satisfied that you understand that?
I understand it.
All right. Court finds that the defendant has been notified of both the indefinite term Reagan-Tokes and also post-release control. And we have 153 days of jail time credit and no restitution. Any other preliminary matters before we get started?
Nothing from the state, Judge. Thank you.
All right, Mr. View, on behalf of the state.
Your Honor, before the state's presentation, Ms. Kennard does have a victim impact statement for the court on behalf of the two victims and their family.
Good morning. On behalf of Robert, he said that Ms. Edwards, he will not forgive you. That slap, when you slapped him, hurt a lot, and that you also hurt his sister. As far as from the mom, Rebecca, she hopes, she doesn't know if Ms. Edwards has children or not, but she wants that the defendant to know that this crime has greatly affected the kids, especially Robin. Poor Rebecca can't even go to the bathroom by herself because Robin doesn't want to be left alone. She even just walking to the information booth to try to get a hold of me broke down in tears. She has no sense of peace. The kids have no sense of peace. They are currently in counseling and will be in counseling for a while. And I think the family just wants the defendant to know that there is a great long-lasting effect on the kids due to the defendant's actions. And the family would like to see her sentenced to more than 10 years in prison.
Thank you. Mr. View?
Your Honor, in terms of the state's recommendation for the case, I think there are a number of aggravating factors for the court to consider in terms of the seriousness and recidivism factors for the case. I think, first and foremost, that Ms. Edwards was on supervision for multiple felonies at the time of this offense. We have major felony crimes of violence, the victims of which are innocent children. As Ms. Kennard indicated, I think the impact on these children of the defendant's crimes are significant, and the court should take those into consideration in determining the seriousness of the case and the appropriate sentence. I think it is telling that Ms. Edwards was in no way really cooperative with the pre-sentence investigation in terms of what her personal situation was, denying any real substance abuse issues in the case, but at the same time testing positive for fentanyl and cocaine, amphetamines at the time. Clearly, at the time she was arrested on this offense, she was in possession of drug paraphernalia and likely was under the influence from the state's perspective at the time that she committed these offenses. I think that those factors the court can look at as aggravating factors in coming to an appropriate sentence. The state's recommendation as to counts 1 and 3, each for the 2 victims. The state's opinion is that though there are 2 separate victims in this case, there are 2 separate harms, and that the court should not merge those and should run those consecutive. As to count 1, the state's recommendation is a 5-year prison sentence to a maximum indefinite sentence of 7.5 years, and a 5-year prison sentence as to count 3, and that those should run consecutive for a prison sentence of 10 to 12.5 years. As to count 5, I think the court could make findings if appropriate to merge that. I think the factual scenario is that the robbery is part of the kidnapping, and in the state's perspective, certainly the impact on the children and the conduct related to the children is the more serious of the offenses rather than the theft of the vehicle that was the subject of the robbery. So in that circumstance, if the court were to not merge those offenses, the state would recommend a 5-year concurrent sentence as to that. But if the court were to merge those, then the state would elect to proceed on counts 1 and 3. Thank you, Your Honor.
Mr. Martinez, anything from probation?
The only statement in regards to probation's standpoint on this case would be that due to the conduct that took place and the harm that was done to the victims, both children, the recommendation is that the defendant be sentenced to prison.
Mr. Engel?
Thank you, Your Honor. I first note our position is we do believe that the robbery offense should merge with the kidnapping offense. As I understand, 2 kidnapping offenses would have different victims, and under 12th District and Supreme Court laws, that would probably be enough so that they would not merge, but the robbery appears to be the same course of conduct. As to this case,
let's talk about merger first. Based upon the facts that are set forth in the PSI, I did read those facts. Also, Dr. Dichting's report did contain some facts as well. Having considered those, based on the facts of this case, I do think that the robbery charges merge into the kidnapping charges. So the court is going to go ahead and make that finding of merger. So we're going to be sentencing on the kidnapping charges only. There we have 2 counts, different victims. I don't think that's even in dispute that those do not merge.
as to sentence, oh, I'm sorry, if I may.
Go ahead.
As to sentencing, Your Honor, I would refer the court to the NGRI evaluation that was done in this case. I believe it is part of the record. If not, we'd ask that be made part of the record here. And the reason I do that is because one of the things that Mr. View mentioned was a suggestion about a lack of acceptance of responsibility, a lack of remorse. And I think you see part of that is a reflection, or how the defendant may present is a reflection of the mental health issues that she had, which I suggest is a significant mitigating factor here. As the court is aware, she has a significant history of mental health issues, including hallucinations that prevent her from.
Ms. Edwards, stop looking back there. You look at me.
But I think what just happened, Your Honor, is a good illustration. I'm looking at page 2 of the NGI report. And even at that point, the NGI evaluator noticed that the defendant would sometimes appear distracted or laugh inappropriately. She was laughing inappropriately, for example, when I was going over some of the forms with her. And it's not, I think, any disrespect to the court or lack of understanding. That is a manifestation of some of the mental health issues that she has. So I'd ask the court to take that into account as well as her responsibility. I'm in no way minimizing the events here. They're obviously very serious events, and I'm sorry that for the trauma that the victims have held. So we'll just leave it at that.
Ms. Edwards, is there anything that you want to tell me?
No, sir.
So I agree with Mr. View that the aggravating circumstances in this case are significant. The harm to these victims is significant. I agree with Mr. Engel a little bit that you have some mental health issues, but it seems pretty clear from Dr. Nichting's report that she thinks that you are exaggerating your mental health symptoms. It appears also from the PSI that you sort of pull the mental illness card out and play it. And I do think that you have some mental health issues, but I do not think that they rise to anywhere near the level that you portray them to be. And I think that you are a danger to my community, Ms. Edwards. I'm going to sentence you to 6 years in prison on each of these charges. I'm going to order that they be served concurrently, so it is going to be a total of a 6 to 9 year prison term. The Reagan-Tokes or indefinite sentence applies, which means that you're presumed to be released at the minimum term, but they might keep you up to the 9 years if you don't behave yourself while you're there. Based upon this sentence, I find that you are indigent for the purposes of fines and costs. There will be no financial sanctions. This includes the mandatory period of post-release control. That means the adult parole authority is going to supervise you upon your release. That is going to be anywhere from 18 months to 3 years. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for the new felony. We need to credit for the 153 days that you have already done. Is there anything else we need to do? Anything that I forgot?
You did order that she register with the victim.
Oh, yes, and she is required to register as a violent offender.
Nothing additional from the state judge. Thank you.
Nothing else, Ron.
All right, Ms. Edwards, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they will all be provided to you at no charge. Good luck to you, Ms. Edwards.
Once again, has everybody read this pre-sentence report and no other changes?
That'd be the only objection, Judge.
Okay.
No, everything else is correct.
I have no objection, Judge.
I'm sure you're reading this in the report, Judge. This is it's not like stealing cash directly from it. It was mostly using the credit card for unauthorized purchases that were personal, not for business purpose.
Okay, so the point you're making this.
I just want to make sure that you knew was that I was just like robbing the safe in the middle of the night. I just make sure that you knew where that was, how the money came. We figured out what restitution was. We had to look for non-association versus association. That's where there was a difference in the restitution versus what was initially alleged as well.
So no, you're trailing off. Go ahead.
It's as long as I'm just making sure that you saw that what that was in there is that it was the use of the credit card, not just going in like pulling cash out of the safe or something.
How does that?
It doesn't mean anything.
That's apples and oranges.
Yeah.
Both fruit.
Yeah, they're supposed to. It's like she's wearing like a burglar suit, go in the middle of the night and break into the safe. That's what I'm getting at. But there's no excuse in the context. As you see, she's remorseful.
I understand, but once again, she was put in a position of trust and misused of it.
Yes, Judge.
To the detriment of the organization. And sometimes this happens here, and there's a big difference between people who are funneling out proceeds and then they're buying food.
Well, this was for a lot of this was for personal family stuff.
Cruise payments, cheerleading fees.
Cheerleading, that's children.
Come
yes.
on.
But
anything else? I mean, that stings. You know it.
It does. And
I mean, we're not talking about this is having a good time.
Right. She's also lost her reputation, her career.
Well,
and
what else could be expected in this? She betrayed a position of trust, and when you're given a position of trust, you have a lot of flexibility and freedom, and numerous people rely on the integrity and the honesty of it. And here we're still out. I mean, there was a significant amount. Good thing you paid as much back as you can, because a lot of times folks don't. But here it's still thousands of dollars are still missing. And we're talking about losses since August of 21. This is over 4 years later, and the loss of value of it, is still, that adds up.
Yes, Judge. And we've been doing it for some time too. I think she paid this back before she was charged.
Did she pay back with interest though? No. No, I know that doesn't happen, but we all agree it ought to be.
I understand.
It's just not the way it is. Right. But nonetheless, even when they get back the last dime of the actual money lost, they've lost the value over 4 years of it, so they're out.
It's not, and I'm not discounting anything.
I know. Let me see this case you're talking about.
The difference that we're talking about is whether it's a deferred probation, whether it's conviction or not. And you can also make a finding that is not in the interest of justice to ever steal this. And I'd be perfectly happy with that. I just don't want her. I want her to just pay for what she did, but not be forever.
Yes, sir. I understand.
For it. And that was the kind of the issue.
You're being a good lawyer. That's you're representing your client vigorously. Good. You many times folks don't hear, and but it's always a good thing because that's important.
And I didn't highlight the part of that, Judge, but it's pretty much just the last point of error. Just says that lay witnesses should not give an opinion on proper confinement and punishment, and that's really all it is. A lot of other points of error still matter for our folks.
I'm going to highlight.
Oh yeah, absolutely. That's your copy, Judge. I just didn't want to touch your copy if I was giving it to you. I tried to be suggestive. It's just argumentative instead.
Okay. Let me see that letter.
It's right there, just.
No, here, you can have that.
Just
Okay. You were referring to obviously the last
just
two of the last three sentences.
correct, Judge. That's correct.
All right. And the court has, the district attorney's office has requested the court consider this. And this is referred to as a supplemental PSI report memorandum. And it's from Caleb Mitchell, who is president of the Jefferson County Sheriff's Association, I presume. And your objection is noted, and the court is not going to consider the first and second sentence of the last three sentences of that, but I am going to consider everything else.
Yes,
because everything else does speak to the harm that occurred to the organization, which is the entity that seems, which is the actual victim in this case, the Jefferson County Sheriff's Association. So, but once again, people from time to time make comments about what the punishment should be, but only the jury and the court really has that final determination, depending upon what the defendant elects. So, anybody else want to add something here?
Nothing further, Judge.
Okay, your request on behalf of the defendant is what?
I'm requesting for a deferred adjudication, and you are very welcome to make a finding that it's not in the interest of justice to ever be eligible for non-disclosure. The statutory authority does allow you to do that. And if you do make that finding, then she can't seal this in the future. And I know that's the big issue is they don't want her to be able to hide this in the future. They wait down the road to ever, be put in that position of trust. And we have no problem with you making that finding, Judge. I think that would be highly appropriate in this case to make the Jefferson County Sheriff's Association responsible in their feelings.
Anything else?
And of course, the restitution, Judge, we know she must be at the last part of it.
And
Judge, because of the position she was placed in and the organization she was placed in a position of trust that allowed her to work without them looking over her shoulder because they did trust her, and then to come back and find out that she's taking money from them. It's not only hurt that, but it put a black eye on the association itself. So we're asking for a straight probation, that she have a conviction, that follow her everywhere so everybody knows, look out, because if she gets in financial trouble, this is a possibility. We want to make sure that we protect further future victims. And we also make sure that the position she's placed in know that they need to keep an extra eye on her if they do place her in a position of trust. So I think it's a fair resolution for the fact that she took it for such a long time and for the money that she took and from who she took it from.
Okay. And ma'am, is there anything that you would like to add here, Ms. Lewis, before the court makes its decision? This is your time. Your attorney has spoken for you.
I prefer you wouldn't just always makes me
whatever you wish. And you certainly can follow your attorney's advice.
Yes.
Yeah, you, nothing else?
Yes, sir.
Okay. You did make a statement to the pre-sentence officer, and here it's related in 2 paragraphs here on page 2. So you stand by that. Okay. Anything else?
No further, Judge.
All right. If nothing further, the court is going to find that Ms. Lewis, you have pleaded guilty in this case to misapplication of fiduciary or financial property, a 3rd-degree felony. You have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at your hearing to find you guilty beyond a reasonable doubt. One final thing, how much credit does she have on service? How much, well, do you have any time serving in jail on this? You went in and bonded out, I guess. She says there's none. I trust that she would know better than anybody else.
Yeah.
One day, that was when you came in and then bonded out immediately, and they give you credit. All right, here's the court's ruling. I find you guilty beyond a reasonable doubt of this offense, and you are hereby said that's a 3rd-degree felony. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. But I am suspending that and placing you on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You had a total law. There was a total loss here to the Sheriff's Association in the amount of $37,102.91, of which a balance toward that replacement or restitution of those funds in the amount of $8,966.09 shall be ordered to be paid as a condition of probation. And you said, I think, that you could pay as much as $300 per month.
Yes.
And that will be ordered at least $300 per month will be ordered to be paid toward restitution. There will be terms and conditions of probation, which are normal and customary. The court would also add for the record, this particular situation and crime involved illegally taking advantage of a position of trust. You understand that. It's obvious that you have admitted in an attempt to resolve this in an appropriate way. I just wish we could have talked you into not making those choices in the first place, because these are clearly wrong. And something like this is ultimately going to collapse. Somebody's going to find out about it. There's going to be an audit. It's just waiting to fall. It's a shoe waiting to fall. And maybe that bothered you and kept you up at night. But nonetheless, you had, according to the pre-sentence report, 186 separate transactions that you illegally accessed since August of 2021. And these involved expenditures of that had absolutely nothing to do with the purpose of the money that was properly placed into the sheriff's organization, sheriff's association, that should have been used for the purposes that the sheriff's association statements in their incorporation and what that professional entity was entitled to use those for. And those are limited purposes, but it had nothing to do. It had absolutely nothing to do with what you accessed improperly and used those that $36,515.34 for, such as your daughter's cheerleading, childcare, school fees, rent, utilities, and personal subscriptions, and other personal matters, which also included airline tickets. And we can go on, but I think the point is made. You understand it. You have admitted responsibility and are pretty much throwing yourself onto the mercy of this court and your intent to help your kids enjoy life and provide for them and what they wanted, contradicted with the obligations that you had in your responsibilities of honest maintenance and control of the Sheriff's Association monies. And so when something happens like this, the price is as serious as it should be. I just wish I could have whispered in your ear, don't do this at the beginning. But you have accepted responsibility, and that is important. Now, these also, such a betrayal of trust also doesn't just walk out of here without the issue of I can assess up to 180 days in the county jail as a condition of your probation. What do the parties say to that?
Judge, in these kind of cases, the court has always given some that's discretion as far as the time. I don't know, since she's paid some back, she should be given some credit for that.
I think so. Yeah.
So somewhere around 30 days, maybe up front.
Judge, now we want her to pay restitution.
Sir,
he's got $8,000 left. Put her in jail is going to take her. I mean, she has a job that now she's going to pick a felon. We don't want her losing her job and not being able to pay restitution back. That really kind of wasn't our agreement on our plea bargain. We talked about a term of probation is the length and the type, not the condition. I understand that,
but your argument is don't hold me hostage.
Not only hostage,
I know you don't, but
I'm giving Mike a hard time because he asked for jail.
You're vigorously
what we agreed on. So
and
it's personally between me and him, not the court.
Or
that was not, well, it wasn't part of the plea agreement.
Correct.
That's correct.
It
wasn't.
My discretion.
I understand that.
I can do that up to 180 days, and she's going to go to jail. You know, with anybody in a position of trust like this, it's going to go to jail. But what I'm going to do is, what are your days of work?
Monday through Friday.
Monday through Friday. I'm going to order you to serve 30 days in the county jail on successive weekends, beginning each Friday. You must report on it before 6:00 p.m. You'll be released Sunday, and that'll be for 15 weekends, successive weekends, as a condition of this probation. Do you understand? Can you work that out? When can you begin that? Today's Friday. I'm going to give you 1 week. Is that enough time? Beginning next Friday, on before 6:00 p.m. in each successive weekend, until 30 days are served, or unless this court decides otherwise to reduce that time. Dustin, did you hear that?
Yes, Judge, I was making sure.
Okay.
That's clarified.
Okay, you just want to.
So next Friday.
Has discretion and we'll see how things play out. And this restitution, let me ask you this. This still is not $8,966. Is there any possible way you're able to pay that restitution earlier than over time? I don't know. I'm just asking you that. I reward people who do that, if you know what I mean.
Yes.
Towards conditions of probation. Okay.
I've talked with her about it.
All right. See what you. All right. Did we cover all the bases on this? Anything else?
Okay.
If not, we are in recess on this. I'll sign. Yeah. Let me sign these orders and get the probation office to get copies to everybody. That's it. That's it. Joe's. You chose like very good about it. So in your name. One. That'd be about. How many do you get done? Let's put him out. Something wrong with you, right? Something wrong. Something wrong. Something wrong. We had him. No, you gotta get that right. So if you card and tell me that doesn't say one to say. We don't go through it. Yeah, I don't know where everybody is. Is this really print on the final page of these? Was that right? Hey, Aaron? That was the final page there, and I just signed it, but.
Oh, we usually send it before we sneak.
Okay. Yes, thank you. Yes, I didn't see that.
They could stay in the camera with that and you could take the 3 notes number.
Okay, Eric.
Thank you. That's everything. I'm not big.
We've been following you.
Thank you. That's what you're doing. When I'm tired, you try to look for me. And I say it's nothing.
I have Sabrina Gallagher.
Discussing with Ms. Gasper some options for resolving the case.
And how's that going?
We talked earlier this week, and then I've been in trial, and I don't think we got a resolution yet. But we want to. Yeah, it's weird. It seems like this could.
They all look alike.
They all look alike. They do make a lot of sense. But in part,
what do you want to do today?
I guess I'm going to ask maybe for a review in 3 weeks or something so that we can continue our discussions.
2 weeks good enough for everybody?
My only issue is I'm going to be out of town on that Friday. I could have that third week. That's the week.
All right. Is that good?
That's fine.
Okay. You said 3 weeks at your request to the parties. Thank you.
Thank you, Judges.
So that's Sabrina.
You can say names.
Daniel Harvey is 2 cases.
I'm already with.
You're going to be here.
All right, Daniel Harvey.
Yeah.
Yeah, and also against Francisco Torres.
That'll be faster than this if you want to do that.
Francisco Torres first. Let's do Mr. Torres. 23 CO 531 Francisco Torres. I'm looking at a plea here.
Yes, Judge, we're getting super close to a resolution.
Not today. I don't see anything.
Maybe yours.
I'm going to speak with Mr. Laird on it. We may have it worked out, but I'm going to
today.
check and see. If we'd have a week or two, Your Honor, just to go through it.
2 weeks.
Yeah, 3 weeks. I'm still on that 2.
Oh, that's right.
3 weeks. Yeah.
Well, you can do it next week. You know what? I think
what was that Friday as well?
Yeah, more than not doing the service.
Hey, what do we, next week, that's just short. So, what am I, what do you get through Wednesday?
Yes.
Wednesday. So we're.
Maybe it's Thursday, Friday, next week.
Yeah.
Yes, sir. We'll have some by then, whether or not we're back.
Okay. All right. Back on the record on Francisco Torres when?
Wednesday of next week.
Wednesday of next week?
Yes,
good. Okay. Please get a reset and thank you. Daniel Harvey, please. Anything else on this docket other than, is this?
Mr. Torres.
Mr. Harvey.
Oh.
I got a bunch of people here in the crowd.
You had an ex parte with, Gonzalo Alvarado.
Yeah, I'm aware of that.
It's hearing, it's asking for ex parte assistance.
All right. 2 cases. 24 CR 1041, obstruction of retaliation, and 24 CR 1818, state jail felony will be legal possession of a controlled substance. No priors. And go ahead.
So Judge,
you're the movement, I think.
No, actually, the court's the movement. You set conditions of his bond on November 11th. Ordering, he was in custody with a no bond. You set his bond at 50,000. With the drug patch, GPS device, home confinement. You gave him exceptions for work, seeing his attorney, and medical needs.
Okay. I think that was on September
11th. And then, you got an email. Yes, sir.
Hold up. Do you know you said November?
I'm sorry. I apologize.
He's been waiting.
We all looked at each other, but we let you.
We let you keep going ahead.
Okay.
We let you go for it just to see
I appreciate
down that road you were going to
appreciate
take. But nonetheless,
September 11th.
Today is what?
Judge, in the wake of that, Mr. Ham and I were notified that a Beaumont police officer has reached out to the court and suggested that Mr. Harvey was not in compliance with his GPS device. I have since had a very, very stern conversation with him about the terms and parameters of his bond and how the GPS device works and how he needs to comply with it. And
that as a practical matter, Judge, I went back and reviewed the transcript and the court told him not to be ambling about and told him to be at home or work for his lawyer's office or medical appointments, things of that nature. But didn't specify home confinement. Mr. Harvey did not get any kind of written bond conditions when he bonded out. But I have now told him very thoroughly that that is exactly what that means, he is supposed to be at home other than being at work or being in my office or in court or medical appointments.
Make copies for everybody of this. This is the order that the memorandum that was entered on 9/11. Was it 9/11?
It was, Judge.
He wasn't providing a copy of that.
No, but I articulated them on the record at the time. But it's like we always do. We make memos and try to get them out to people, but it's on the record. Well, for folks to see and be aware of.
I filed a written objection relating to the obtaining of this evidence because I have a very
obtaining of the what evidence? What are you talking?
A police officer being able to log in and just see where he is into some system and just tap into the GPS system and track his whereabouts whenever he wants to. And as it turns out, it's the police officer who is the complainant in the retaliation case, which I have a real problem with.
So what are you asking?
I'm asking for the court to disregard that information and evidence. It hadn't even been presented yet, but to disregard the information and evidence that was obtained solely through.
All I want is right now. All I want is to get the conditions of bond done before something bad happens on my watch.
Right.
That's all. Somebody, because it's shame on someone else, not me.
I agree.
Yeah. And here's another one for here. And yeah, people are keeping an eye on it. There's no reason they shouldn't be. And if I'm alerted to a condition of bond, any citizen, anybody, so help me police my job because I'm not out watching everybody. I can't do that. Is there anything about those bond conditions we set that you didn't understand? I'm talking to you. Is there anything about those bond conditions I said that you are confused over?
And so that would be better than the crowd. What do you say? He said it was a couple things, but Judge, we clarified them now. He's not confused anymore. I have talked to him. He's not confused anymore. And I think he understands exactly how.
I expect the court's orders to be followed, or else somebody gets in trouble. It's a court order. You have lost some of your freedoms. Yes, that's just what happens when you're charged with a crime sometimes. Yes, and what this court can do is, if I'm not satisfied with what you're doing, I can revoke your bond and you can sit it out in jail until we can get this thing disposed of. It happens from time to time.
I'll remind the court that this was at a no bond status before he left. And I agree with Officer Jackson that all this conduct that was brought to the court's attention is the fact that this young man is not taking any of this seriously at all. One of the conditions that, when he left the courtroom, it was really clear that what his lawyer advocated for him was that he'd be allowed to take care of work, see his attorney, and take care of his medical needs. And instead, 2 days later, he spends 3 hours wandering around one of the local parks. There's nothing about that can be argued is in any fashion whatsoever associated with those terms. And he does that right on the eve, right after you instruct him not to do that. And this, saying I didn't have this memorandum, that's an interesting legal argument, but the fact is he stood right where he's standing right there and didn't understand what you told him. How are we going to have any guarantees going to understand this? His lawyer might, but this sure doesn't connotate to the defendant.
Okay, is there's a motion to revoke probation in a misdemeanor court?
Yes,
Is that right?
Yes, sir. I brought that up whenever, because I was pointing out to the court that he can't seem to follow rules.
All right, these are also over a year old.
Yes,
What
sir.
are we doing?
It's on the trial docket right now for a date in December.
Okay. We're going on the 3rd-degree felon, I guess.
Probably, Judge, just because it carries more weight.
Well, that's what normally is done, but I just.
It's going to turn on where I'm at with evidence and all as far as. it's
Okay,
concerned.
get ready for trial then.
Yes, sir.
You got my attention, which you don't want. Anything else? Who else? Anybody else? I'll hold in the fine stuff.
Got the ex parte letter, Judge. You could
Yeah.
take that.
So let me get that. Is that a 5? What do you have? What is the name of the case? Jimmy?
Sorry, Judge, on the article on the ex parte?
It's Alvarado.
Yes.
All right. I need that. Okay, how do we want to do this?
Judge, before we get started, I've been informed that the mother of the complaining witness is in the courtroom as well. She's not the listed complaining witness, however, she is the mother of the child. We'd ask that if this is an ex parte hearing, it should be asked.
What is it? Is it on this file, on this motion?
Yes, Your Honor, there's additional exhibits. One that I was not able to file because it's a JPEG, it's an image, is the monthly breakdown of how much he makes versus how much his monthly expenses are.
Good, if you'll give us a minute to get out. So don't you do the ex parte hearing?
Okay. What we'll do is clear the courtroom. Thank you for this hearing. Thank you.
The parents are here, but we can send this to outside unless you want to speak with them for confirmation of any of the statements that are made.
Thank you, Judge.
Yes. Everybody can stay out. Yeah, everybody.
Y'all can go outside. If the court needs you, they'll call you back.
Thank you.
Thank you very much.
All right, this is an ex parte matter. The court will go mute.
Of Livingston County, the judge issued a very thoughtful opinion, says you can't do this. Well, this is lot and trailer, so you can do this under any theory. But as it gives people an opportunity to redeem, to pay the rent. And my recollection is during COVID, they did pay lot rent. And so same thing, legal aid wasn't in a position or didn't wish to argue that, hey, you can't do this because it was benefited the tenant if they get to pay the rent rather than simply a just cause termination with no other option but to vacate.
So
here's Kyle and Shasta. Who are they? That would be a 940 case for Golden Pond.
Not us. Okay, good.
No, it's not.
I don't. And I had a lot of them this morning, but that
Now, we've been struggling with, we've got a lot of mobile home cases this summer. Both of your parks, Rebecca, are hooked up to city sewer and water. Colonial Estates is White Pigeon, Whispering Pines is Constantine.
Correct.
The ones without it we've got built-in problems. But Centerville, Three Rivers, Golden, but no, the ones,
Riverside.
Memory Lane is hooked in, has city.
Memory Lane is hooked into Sturgis,
Yes,
special agreement.
Sturgis sewer.
They've been hooked up for a number of years, but yeah, we've got several. Miss Coons, can you hear me?
Yes, I can.
All right, you're in the right place. You're just a little early. So I'm going to put you in the waiting room. Don't go away, all right?
Okay.
Thank you.
I like it when you're here early. It helps us stay on track. So I'll be with you in just a minute.
Okay.
As soon as we click the clock to 9:30, we'll switch gears for those folks. Elaine's so smart. That's why she sets these 5 minutes apart, because she knows that some of them will resolve.
I was going to opine a little bit on your discussion about rental assistance with mobile home parks. It seems that the primary concern is when the tenancy is a financed purchase. So if the person's renting the home or the lot, both are okay for assistance, but we see some pretty strange purchase agreements, and that's where it seems to me the federal agencies, or I'm sorry, the state agencies start to pump the brakes.
They don't want to pay.
They won't
They don't want to pay.
provide funding for your mortgage if you're not making your house payment and it's a financed home. In most cases, they don't provide assistance for that. And you're right, they come in some nuanced contracts. All right, well, we got 4 minutes to think about things.
Judge Pattison back, or is he still gone?
He's back. He's here today and he's got a docket. He'll be gone next week. And I'll be here. Judge Stutzman says he has a trial next week. Here's your client, Miss Parks.
Excellent.
So we'll bring Kyle and Shasta in and we'll advise everybody of their rights and we'll Good morning. Are you Katie Parks?
I am.
Can you hear me?
Yes. Can you hear me?
Yes, I can. All right. Mr. Sluice and Ms. Kuntz, you're here also. Let me tell all of you, you are tenants in a landlord-tenant proceeding. Your landlord has brought an action to have you pay the rent.
It's called a non-payment of rent case, amazingly. In such a case, you have a right to hire an attorney. If you cannot afford an attorney, you could ask legal aid to represent you or seek other legal representation. An attorney from legal aid is here with us on the feed this morning. You have a right to have the case heard where the property is located, which is beautiful St. Joseph County. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or file the jury demand within 5 days in writing using the court form, and be prepared to pay the $50 jury demand fee unless the judge waives it for your inability to pay it. You may be eligible for financial assistance if your landlord has asked you to be evicted from a residential property because you haven't paid rent. You may be able to get assistance from the Michigan Department of Health and Human Services, Local Coordinated Entry Agency, which is Community Action Agency out of Battle Creek, Housing Assessment and Resource Agency, which is Neighborhoods, Inc., or if you're a veteran, you may be eligible for some federal veterans assistance programs. You should have received that information with the original summons and packet that we sent to you. You do not need a judgment against you to receive help from the places listed above. A copy of the summons and complaint from your case are sufficient, and you've already received that. You may be able to reach an agreement with the landlord by going through mediation, also known as community dispute resolution. If both parties are interested, we can set that up. Or if you can reach an agreement with the landlord that the case would be dismissed for payment of rent or some other agreement, they could file what's called a conditional order of dismissal. Ms. Parks, is Mr. Heminger there?
Randy does not live here any longer.
All right. While we were waiting, we ran some of the numbers. You weren't late. We just had a time gap. So we were using some of the time to get prepared for your case. The park contends that your rent is $4,590 in arrears, plus court costs of $208 for a total of $4,798.33. You have filed, it appears that you filed a request for some financial assistance with DHS. Is that correct?
That is correct.
Do you agree with the numbers?
I do.
Have you heard anything from DHS?
Yesterday, I contacted them and they did deny it a couple days ago, and then going over the reasons why it was denied, she told me to refill out the paperwork, and then they're going to reprocess that with, I'm guessing, a different answer.
Are you employed?
I am currently getting unemployment, and that just started on the 19th.
Reason I ask, if they give you some money, let's just say the DHS says, all right, we'll pay $3,500. You would still owe an additional $2,300 to pay the rest of this. The only thing that cures this is paying the entire amount. A partial payment will not prevent the writ of eviction. This is pretty substantial arrearage. With costs, it's up near $5,000. It's unlikely they're going to give you $5,000. They might, I've seen it before. But if they don't give you that, you're responsible for the balance. My original intention, Mr. Reed, was to adjourn this a week, but it looks like she is in the process, and now there looks like there's going to be a delay. So the law says when they've asked for assistance, the preference is we adjourn 2 weeks. So let's see what we got here. We're already into October anyway. Do you no longer do Three Rivers Village?
Rivers Village.
Is that the
Oh,
a mobile home park there?
no, what is? Yeah, I can't remember the
Yeah,
name.
there's the Paylets law firm seems to be representing them.
Yeah,
I thought maybe it would be you. How about 10:30 on Friday, October 10th?
I have
Boy,
a
are we-
mediation. I'm available that afternoon.
Well, let's see what else we got. How about 8:30?
No, I'm in mediation all morning.
All right, well, let's split the difference here. Let's say we got for the 13th.
13th, I'm pretty wide open.
How about if we'd set it for 2:00 on October 13th?
Works for me.
All right, we're going to continue this 10 days and see how you're doing with DHS. Now, part of the reason you got behind is because Mr. Heminger left. He lost his income.
We divorced in April.
All right.
And I have not received any payment from him at all as far as child support.
Who else lives there with you?
Myself and my 3 children.
All right, well, this is a tough situation. Your kids are in the school district there. You wish to stay there. Your rent arrearage is pretty substantial. This figure I gave you was through September. When we get into October, it's going to be higher still. I used to include that number in here, but I was told I can't do that anymore. What's the monthly cost here?
I believe it is $985.
That, yeah, with the garbage fee. Yes, sorry.
So add that into the figure of $47.98. So you're going to be close to $6,600. So share that with DHS. But when we meet next time, October's rent will also be due.
Correct.
Okay. And do you have a plan B if you can't get any assistance?
I do not.
I believe the monthly amount with the garbage fee is $934.
$934?
Yeah.
Yes. Well, let me talk about the worst case scenario. If you don't pay the rent on October 13th, you would get 10 more days to move or be subject to being evicted, which would be October 23rd. So that's 20 days from now. So I really hope you can light a fire under somebody at DHS. But then, of course, on the 1st of November, November's rent is going to be due. And so.
I do have money coming in now.
All right, well, very good. Hopefully you can get caught up with this. I'm not encouraging an eviction. I'm just telling you that that's the worst that could happen is you would have to move out or the sheriff would come put your stuff out on the street. So stay in contact with Ms. Lentz, your manager. DHS may need information from her. Stay in contact with them. The number is $4,798, and it's going to be an additional $934 for October. You and I will talk about this further at 2:00 on October 13th. Stay in contact with your manager. All right, good luck. Do you have any questions?
I do not.
All right, I'll see you in 10 days.
Thank you.
All right. Thank you, Your Honor.
All right, so we should all get a plan B. All right, all right, Miss Lentz, I'll see you next week.
All right, thank you.
Thanks, Judge. Have a good one. Meg, have a good weekend.
All right.
You too, TJ.
Someone named Andrew Rognus is in the waiting room, but I don't really want to even bring him in. We've gone through the rights with Miss Kuntz and Mr. Sluice. Someone is here from the park. We don't yet have Mr. Cromendike. I'll bring Mr. Rognus in anyway. Good morning, Mr. Rognus.
Your Honor, Meg, how you doing?
Morning,
we got
Andy.
a couple cases before you're up, but we'll wait and see who comes in. We're waiting for an attorney on the 940 case. I expect to be here any minute. You look good today. That looks like a real tie. Oh, I guess not. I guess not. Anyway, it looked good. I'm sorry I spoiled the illusion.
It would seem you've got a reputation to keep, Andy.
I do.
He's upholding Judge McManus's reputation. Ms. Coons, can you turn your camera on? Very good. Good morning.
We have to be outside or we don't get signal.
Well, it's a nice day, so that's all right. All right.
The leaves are
falling. Yes, it's fall. Unfortunately, oh, it's going to be a nice week. You're Shasta Coons and you're Kyle Sluice?
Yes.
Yes, Your Honor.
All right. We've got your manager, Casey Villa, here, and we're waiting for the attorney for the park to join us. I would also note that Megan Bauer is here from Legal Aid if we need to seek advice or information from her. What often happens is the lawyers have to be in more than one court at the same time. We've been pretty good on landlord-tenant days. I've got 2 general civil matters at 10, so I really don't like to get backed up here. Let me ask this, Ms. Coons. You guys rent the lot and the trailer?
So the trailer is on a rent to own.
All right. Meg, that's one of those cases that you mentioned earlier. All right, Mr. Cromendike's here a couple minutes late, but he is here.
Good morning.
Good morning. This is Golden Pond Estates versus Shasta Coons and Mr. Kyle Sluice. We had gone through their rights with them while we were waiting, and we've done that. Mr. Steve Cromendike is here on behalf of the plaintiff, and their manager, KCV, is here. This is one of those, what part of it is lot rent, part of it is a rent to own for the trailer. Sometimes hard to sort it all out. This park also has some sort of a utility fee that I've been learning about. So, Mr. Cromendike, what's the arrearage here?
And just so we're clear, I think the original complaint included some of that that rent to own or loan payments on the mobile home itself. I have taken those out of the numbers I'm going to give you now. So there is outstanding lot rent at $395 a month, totaling $1,975. In addition to that, we have $250 of late fees, and that's at $50 a month. And then we have a $60 NSF fee for a payment that didn't go through. And then there are $356.72 of outstanding utilities fees. That total is $2,641.72. In addition to that,
all right, go ahead.
We've got court costs totaling $308.20.
Give me that again, please.
Court costs are $308.20.
Thank you.
And so the total amount to retain possession would be $2,000, as of right now, would be $2,949.92.
And that does not include the trailer payment.
Correct.
All right. Their claim is that you are $1975 a lot rent, 5 months worth of late fees, and NSF fee, and this utilities for $2641.72 just on the lot. What's your position with that?
I had applied through DHS for some help for the total amount that was on this paperwork. And I got a denial just in the mail the other day because something to do with it, this paperwork didn't reach them in time. So I have to resubmit that. But the problem being is I can't access my mail at this park. I've asked repeatedly for keys. The entire time I've lived here, I cannot get mail here. So I have to have everything deferred to my parents' house in Marcellus. And that's where the DHS paperwork has to go. So when
you don't live in Marcellus. Marcellus is in Cass County.
Right. My case is out of St. Joe County, but they mail my paperwork to Marcellus because I can't access my mail at this address.
Just a minute. Ms. Villa, could you join us?
And we requested the key multiple times.
Ms. Villa? Is there a big mail delivery?
There's a box and it has keys.
Yeah, at the front of the park, there's a box with a link, all the keys for each unit.
And you don't have a key to it?
Never received one. I've reached out to Trish, the person I was told to reach out to numerous times. I never received the keys. I talked to the mail person. They said they had to provide the key to us, that they couldn't change them.
I've got a note taken down, and I will let the owner of the park know, and hopefully get that resolved as quickly as possible for you.
Okay, thank you.
Now, this is complicated. Some of it is utilities, some of it is lot rent. They will assist you with the lot rent, but they won't assist you with your payment on the trailer.
Right.
Like if you were buying a house, they won't pay your mortgage. They'll pay your rent, but they won't pay a mortgage. So there's even more money due on the trailer payment. which is not a part of this.
Right.
How is your water? Does your water and sewer work?
It's disgusting. It's not
Water's
usable.
yellow.
It's brown to yellow. It stinks.
It stains our clothes if we wash clothes with it.
I don't even wash my clothes here anymore.
Yeah, something's going on with their water.
Does your sewer work?
It works, but so if you use the toilet or even like the shower, the toilet, or when we would use the washing machine in the back half of the house, it would smell.
It would regurgitate putrid
like
smell.
Dead fish.
All right. Well, there's some issues here. The park has got these issues. Megan, do we know if they've got a proper certification for operation yet?
We do, Your Honor. We just received it yesterday from the state.
Very good. Very good. So we got that not to worry about, but there's other issues.
And as far as the water goes, Your Honor, I hear what's being said. I had provided Meg with the water is tested monthly, is my understanding.
Well, it's tested at the wellhead. It's not tested at the faucet in the individual trailers.
Yeah, that I don't know that. Yeah.
And I don't know. Like I said, I had sent the health department out there years ago, but they didn't want to condemn make everybody homeless. But this park needs some work. I think the septic is bad, and I think the water to the individual trailers is bad. At any rate, they have requested some financial assistance. So in theory, I'm supposed to adjourn this for 2 weeks.
Judge, I am, of course, happy to consult with the tenants if they're interested in applying for legal aid.
Yes, please. Yes, please.
All right. Let's look at a date. Mr. Cromendike is trying to get the park all situated here, and there's just some issues that are unresolved. That takes us to Friday, October 10th, and that is a better day. Are you available at 10:30 that day?
Yes.
Are you, Mr. Cromendike?
I am.
In order to cure this, you have to pay the entire amount of the rent. So right now it's, and the other thing, when we come back again, it will also include October's rent. And so we'll be over $3,000. That's just the trailer lot payment. Also, you owe the payment on the trailer.
Yes.
I don't know. I haven't been there in some time. Maybe if everybody in the whole park paid their rent into escrow, rather than pay the rent, we'd have a bunch of hearings about the habitability of these premises. But we're going to continue this to October 10th. So you got two problems. A, you need to pay the entire amount to cure it. And B, this is lot only, not the trailer payment.
Right.
So so you've got multiple issues. Are you both employed?
I just started work again because there's been a lot, but I don't want to get into that right this second. But Kyle's doing DoorDash as well. We've just had a rough year. Easy way to explain it.
Well, I think a lot of people are fighting that same struggle. I'm going to put you in a breakout room and let you talk to legal aid privately.
Okay.
But our next hearing will be Friday, October 10th at 10:30. All right. You should just click the button that says join. Wait, May.
Thank you, Judge.
What? Okay,
She's going to come in, she's at her house.
that's
We have
fine.
no internet at the office, but she says she has a German Shepherd. She apologizes.
Make the best of it. All right, Mr. Commandite, you're still with me. Our next matter is 9:45. We're about 8 minutes behind. And that is future vestments versus Koloff. This is a property in Colon. Ms. Villa, I guess we're done. Is anyone be here on behalf of Daniel Koloff? All right. The property appears to be vacant from the service. Let's see if I have a second mailing here. No, I don't.
Surprises me. We almost always do that, but I'm not doubting you. Just to be clear here, Your Honor.
If you can see one, let me know. I
actually do have one here. I've got it in my file.
All right, then I'll accept that.
And it was signed by Elaine Gibson, the court clerk, on August 22, it appears. And just to be clear here, this is my client purchased this property at a sheriff's sale. And we're here because they are not being permitted to inspect the property. And so we are seeking possession, but also a termination of the redemption rights.
Yes. All right. We do have a second mailing. We may have a default judgment for possession.
Would you like me to submit that?
Yes, please.
Okay. Perfect.
10 days from today would be the 6th of October. It's clear that nobody's in the property, but I think we better go with the 10-day notice. Maybe there's stuff in there. I don't know.
I don't know either.
Can you wait 10 days?
Yeah. Mm-hmm.
All right. October 6th for the date, and I'll indicate plaintiff will submit order.
We'll get it sent in.
All right. Thanks a lot.
Yeah. Thank you.
I'll see you next time. Thank you. All right. Next is ARLK Properties versus Catherine Smith and Cody Lester. Cody Lester is here. Catherine Smith, no. And Andrew Rognus is here, and Nate from ARLK Properties is present. Mr. Lester, can you hear me?
Yes, sir.
Does Catherine Smith still live there?
Yes, sir.
Where is she?
She's currently with the kids right now.
All right. You're also appearing from outdoors, but it's a beautiful morning.
Yes, sir.
Well, I need to take a minute and advise you of your rights as a tenant. You have a right to hire an attorney. This is filed as a non-payment of rent case. We're going to talk a minute about how much the rent allegedly is. If you can't afford an attorney, you could request legal aid to represent you or seek other legal representation. We don't have court-appointed counsel for civil matters. You have a right to have the case heard here in St. Joseph County where we all live. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court today or file a written jury demand within 5 days and be prepared to pay the $50 jury demand fee unless the court waives it for your inability to pay. You have a right to ask for mediation to settle the matter. If both parties are interested, the court can help set that up. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, Community Action Agency, Neighborhoods, Inc., or a potentially federal veterans program. We sent that information to you with the original packet of information. Finally, if the matter can be resolved, we could seek what's called a conditional order of dismissal. All right, Mr. Agnes, what's the circumstance here?
Well, at this point in time, Your Honor, rent totals $3,600. I'm suspecting if we get adjourned into October, it'll be another $1,200. So it's going to get to the point where it's $4,800. Lease does specify a late fee of $5 per day, which as of today's date would have been $435.
We'll recalculate, we'll leave that out. You can't do a $5 a day late fee.
Okay, well,
no court allows that.
Yeah, the rent is currently $3,600. It'll be $4,800 on the 1st of October, and the total for costs is $232.40.
So it's $3,852.
Okay.
40.
Yep.
All right. Here's Judge Pattison.
Back from California?
Yes. All right. Mr. Lester, do you agree with that?
Yes, sir.
What's your plan?
We're currently working with a couple of different agencies to get some help with that while we get back on track.
All right. Who have you been in contact with?
Her name is Kathy, and Neighborhood.
Which agency?
One of the veteran agencies. I'm not exactly sure the name.
DHS, Community Action Agency, yeah. Neighborhood Inc.
Community Action Agency and Neighborhood Inc.
All right. I said this about 20 times. They scheduled a meeting with those agencies to talk about what funding they had. And I went to it, but they canceled it. I was interested to hear if they had any money. The only thing that'll cure this is paying the entire amount. As Mr. Agnes indicated, there's going to be another month's rent due October 1st. Your rent is substantial, $1,200 a month. That's pretty high for St. Joe County rents. In Chicago, you can rent a doghouse for $1,200 a month, but here it's at the higher end of our spectrum. Because you have requested assistance, I'm supposed to go 2 weeks. Mr. Agnes, which would take us to October 10th at 10:40. Does that work for you?
Yes, sir, Your Honor.
All right, Mr. Lester, a couple things I want to repeat. The only thing that'll cure this is paying the entire amount of the arrearage. So it's gonna be pretty substantial. It's gonna be close to $5,000 when we get into October. So let's say they agree to give you 3,500. You're still gonna need an additional 1,500. And we may revisit late fees. No judge allows $5 a day. I've been up to $50 a month. So if we put that in there, that's going to be additional $200 in late fees, which would make $5,000. If you're unable to pay that, I'm going to give you 10 days from October 10th to vacate or be subject to being evicted. That would give you until October 20th, unless the landlord gives you some grace, to stay or move. I'm sure that ARLK Properties has a waiting list of people looking for something to rent. And the farther they go, the farther behind they get, and their interest may be just to get you to either pay or move. So bear that in mind as you go forward. Couple pieces of advice: stay in contact with your landlord. Let your caseworkers know there's going to be additional month. So the arrearage is going to be, if we add in late fees, $5,000 plus some. All right. Do you have any questions?
No, sir.
All right. Next hearing is 2 weeks from today, October 10th at 10:40. All right. You're good to go, sir.
Okay. Thank you, sir.
Your Honor.
All right. We're going to switch gears to our civil cases. We got 10 o'clock. So we're 4 minutes behind, considering how things were going. Good morning, Mr. Cox.
Morning, Judge.
Ms. Escamilla is here from her world headquarters in Kalamazoo, and Tracy Bice is here. This is file number 25166GC. It's entitled Omni Credit Union versus Tracy Bice. Are you Tracy Bice? Could you unmute your microphone?
Yes, sir. Yes, I am.
All right, good morning. I love us too. You've got a sign behind you that says, I love us. So I guess everybody loves everybody. Anyway, you have a substantial debt to Omni Credit Union. It's north of $15,000. Attorney Escamilla represents Omni Credit Union, and she's here in an effort to collect on this judgment. She's filed what's called a discovery subpoena to compel you to come to court to answer questions for her. To make things more convenient for everybody, I allow this to be done by Zoom. So Ms. Escamilla is here from Kalamazoo, and you're here from Pinhook Road, Mendon. I'm going to ask you to raise your right hand, Ms. Bice. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
All right, Attorney Escamilla is experienced at this. She's going to ask you some questions regarding your ability to pay on this debt. I'm going to put you in a private space called a breakout room. And you can talk privately with her. I will be here when you're done to see if you need any further assistance from the court. But you click the button that says join. You're under oath, you're under subpoena, and you're required to answer her questions. Ms. Escamilla, have anything to add?
No, Your Honor, thank you.
All right, you click the button that says join, and you guys can talk privately. Ms. Shingledecker, can you hear me?
Yes, I'm here.
All right.
Just pointing way up.
I'm not sure what happened. The camera got pushed up in here. Mr. Cox, today's opening line is so easy, even Meg would get it. Hey, where did we go? Days when the rains came, standing in a hollow, playing a new game.
I'm drawing a blank, Judge. I don't think I have enough coffee. I have to think a minute.
Good, look it up.
Okay.
You hit Thunder Road out of the park.
Brown-eyed girl?
Yes, yes.
Van Morrison.
Yes.
Just took me a second. I was thinking Springsteen again, Judge, and I'm like, wait a minute, that's
No, they're complete. The only thing they have in common is that they're songs that I like.
Oh.
Ms. Shingledecker, thank you for your indulgence.
I love music.
Elaine,
so no
could you move that camera down so she doesn't have to stand up like that?
It's kind of tight on there, but
I'm not sure what happened to it.
I think the cord behind is being pulled down, so it's just going right back up. And I don't want to break your camera.
Yes, all right, thank you.
That's okay. You can stand on the chair.
All right, now I would have you here in the courtroom, but by using this conference room, I may be able to let you speak privately with Mr. Cox. So let's call this case. This is file 25489GC. It's entitled Three Rivers Health versus Rebecca Shingledecker. Keith Cox is here on behalf of Three Rivers Health. And we have a lot of these cases, and they're often difficult because they wait a while before they file the actions. And there are often issues regarding insurance. This is a hearing regarding plaintiff's request for discovery and an opportunity perhaps for you two to talk. Mr. Cox, you wish to speak to your motion?
Yeah, Judge. So the court in this case didn't grant discovery in its initial scheduling order, interim pretrial order. The plaintiff interpreted the court's number one to mean discovery would be completed since pursuant to MCR 2.301, which states plainly that discovery is only afforded to the parties by leave of the court or by stipulation of the parties. We weren't able to stipulate on this, or I didn't get any consent from the defendant after filing the motion, but we're here asking for discovery in this case. And as the court knows, I'm here on a lot of these different cases for Three Rivers Health. Typically, plaintiff has all that it needs to go forward with a medical bill case. However, the defense in this action is that this was a botched surgery, that the plaintiff committed some sort of negligence, medical malpractice, if you will, in the rendering of the care. And plaintiff's position on that is that it's a valid defense if it can be established. And the way to be established is to bring in a doctor of equal standing to the one that performed the surgery, and also to testify as to the standard of care that then was breached relative to the procedure. And plaintiff's position, again, would be, we're interested to know if she's really serious about advancing this defense. And if she's not, we might be able to then move up for summary proceedings. So we're asking that the discovery order be granted for 30 days. The discovery that I'm intending to serve upon the defendant is attached to our motion as Exhibit 1, and we'd ask that discovery be afforded plaintiff in this case.
All right. Ms. Shingledecker, I think you got all that. Saying that the care was inadequate or worse is a potential defense to the fact that you owe the money, but you can't just say that. You can say it in your pleadings, but in order to maintain it, you need a medical expert to come in and say this level of care was negligent or inadequate or dangerous. As a layperson, you can't just come in and say, hey, I didn't get good care or they botched my procedure. So it puts the burden sort of back on you. So they've asked for discovery, which means they're going to ask you some questions about the availability or who's going to be your expert to put your theory forward. The other option and I think will avail of it. At least you two can talk to each other. Or maybe you've got an expert in mind. You went to Henry Ford Hospital after this?
I had to go to 2 additional hospitals after Three Rivers Health to be cared for because Kalamazoo Borges Hospital couldn't successfully perform what they needed to do to fix it. So I had to then go to Detroit. I'll be honest with you, Judge. I do not have an expert witness. I'm not financially prepared to hire a lawyer, let alone a financial or an expert.
Have
witness.
you discussed perhaps a medical malpractice case with an attorney?
After all of this happened, a few months following the procedure, I did reach out to multiple attorneys, and in a nutshell, I was one fatality shy of qualifying for a medical malpractice lawsuit. If I would have passed away, it would have been fine, but no one would take my case because I didn't die or I didn't have a life-sustaining injury.
Well, that's slight comfort. Well, if you died, we would have handled your case. It's like saying someone which has been said before, in an assault case, well, if you had died, we would have charged him with murder. But that's not much of a relief to the person that's dead.
No.
All right. Well, what I would like to do is put you in a breakout room to talk for a minute. But I've got somebody in there. I didn't have the foresight to open more than one room. Let me see if I can do more than one.
I'm in a room all by myself.
That's why so I can put you in I'm not afraid to have you here in the courtroom. You came in and said hello. You're in this conference, so I can let you speak privately with Mr. Cox. Let me see if I can open another room. Every time I try to do more than one room, I get sideways. Let me see how they're doing. I interrupted, Miss Escamilla. How are you guys doing?
We're making some progress.
I need to add another breakout room. So let me set up another one and I'll open all those rooms. Ms. Shingledecker, you may need to hit the button that says join. So I'll put everybody back in the breakout rooms and I'll be here.
Okay, thank you.
Thanks, Judge.
I actually managed to do that. For some reason, when I would start to do it, it would affect our sound. All right, we're not in too bad of shape. We've done quite a few matters this morning. We have all the carryover cases of Mr. Bush's, which are 1, 2, 3, 4, 5 Enchanted Glen and then 3 Kreitz cases. So let me take these 2 out. I have a muffin, but I don't have time to eat it. I'll be right back. Ms. Bauer?
Judge, Attorney Popovitz and I are on the phone right now.
All right.
I'm not sure if Elaine was able to get you the memorandum that I bench filed. But
I didn't
realize-
even see your appearance. So no, go ahead. I'll look for it. Maybe it's electronic. I don't, Elaine, do you have any pleadings from legal aid on the next case?
Okay.
Welcome back, Ms. Escamilla, Ms. Bice. Do you need any further help?
No, Your Honor, we've completed all the questions I had. She has agreed to send me the documents we requested in the subpoena. So as long as we see those, we should hopefully be back in your courtroom anytime soon.
All right, very good. Ms. Escamilla, you're good to go. We got through it without nary a bark. Ms. Everling, Ms. Bice, you're good to go.
Thank you.
And hopefully that will resolve the matter.
All right. Thank you, Your Honor.
All right. Thank you.
You're welcome.
Did they file an appearance?
What's that?
Did legal aid file an appearance?
Check. I didn't see.
I didn't see an appearance either. She said she was going to.
Unless she just sent it by email. There wasn't one in there.
All right, thank you. Well, Mr. Kreitz's word of wisdom is the man on top of the mountain didn't fall there. Apparently he didn't read The Free Fall of Webster Cummings by Tom Bodett. Mr. Kreitz, we may end up skipping ahead. Our other matter is set for 10:30, and you guys are then start at 10:45. So we'll see. I'll put you in a waiting room till we get closer here.
Okay, whatever you need to do, whatever you need to do.
Thanks. All right, there's the appearance. That
We
one.
didn't take that.
That's what you see. Yeah, you can have it.
I'll give it to Michelle.
All right, the parties are working on our 1030 case and we'll just wait patiently. I do have a criminal case I need to address. But by the time we get done with landlord-tenant, it'll be lunchtime at the jail. So we'll deal with her after lunch.
Judge, Attorney Popovits wants to speak with his client. So he asked if he could call me back.
That'd be fine.
I know we're at 10:30 here, so I wanted to.
It's fine. We're not in any big time crunch. I'll be here all morning. Our next one's 10:45. If you guys aren't done, I'll just leapfrog you, and those are second hearings and some of John Bush's cases. So we got the rest of the morning if we need it.
Understood. Thank you, Judge.
All right. Reynolds Inc. versus Dana Clark and all other occupants at apartment 2 on Clay Street. Jamie Clark is here. Jamie Kreitz. Jamie Clark's a different person. John Bush. And Mr. Clark is here. This was filed as a non-payment of rent. Mr. Bush, not sure what we determined the rent was. Through September, $3,244. Mr. Bush, anything been paid? Mr. Kreitz?
No, Your Honor. He also did not come in and pick up the packet like you instructed him to either.
Uh-oh, I didn't know anything about a package. Sorry about that, Jamie. I didn't know about that. I apologize. I didn't hear that last week.
Well, you're in a tough spot, Mr. Clark.
Yes, sir. Yes, sir, Mr. Middleton.
You owe $3,244 in rent through September. Just a couple days, October's rent will be due. You owe $197.96 in costs for a total of $3,441.96. That's due within 10 days from today.
Yes, sir, Mr. Middleton. But this package, sorry, Jamie, what package do I supposed to come pick up? You didn't give me a call because I gave you.
No, we talked about that last week on the record. You were going to ask for help from DHS. Did you do that?
No, because
that's why we told you to go pick up the packet.
Oh, hold on, wait. I went to DHS. DHS said that, Mr. Clark, you had to get a hold of your landlord. Your landlord had to give you a eviction notice. And I called you.
All right, well, you're about to get one.
Yes, sir.
So take this to DHS.
Yes, sir.
DHS keeps telling people that they need an actual eviction and they don't.
Uh-oh.
But you're gonna have one in a minute.
Yes, sir.
October 1, how much is the monthly rent?
He set up weekly at 116 a week.
All right, I'll just leave it through. So what's the date of this, Mr. Kreitz?
The 3,244 was through September 22nd. So we could add another 116 for today. For this week.
Mess my judgment all up.
And you're fine. You're fine leaving it at 3,244.
Through not September 22nd.
Sure.
Mr. Clark, I want you to go out to the counter and get a copy of this order.
Yes.
And the clerk will come get it. That's what you need to take to DHS.
Go to the clerk office?
Uh-huh.
Right now, Your Honor?
Mm-hmm. What's the additional amount? 1/6?
It's 116 every week, so you can add 116 to the 3,244. And that
I
would
put it on a line plus 116 per week.
And that'll get him to September 29th.
All right. Partial payment will not prevent the writ of eviction. So he's going to get a copy of this, take it to DHS. Mr. Major is here too. Why don't you come up and have a seat, sir? We'll just keep going while legal aid is working on their case. Good morning, sir.
Good morning.
This is Kreitz Rentals Inc. versus Jose Major. That's you, sir?
Yes.
We were here last week and we went through the information. I don't remember what I put here. I didn't make very good notes. The arrearage is $3,220 plus court costs for a total of $3,422.16. When we talked last time, you were going to try to work on getting this caught up somehow. What's the status here today?
Well, I was gonna make a payment next week for the rest of September. I didn't make enough money to cover last week for this. I'm just trying to catch up some bills that I have, and as you know, I'm separated, and I was gonna apply for some. I'm gonna do the paperwork for emergency funding for housing. No.
Well, we talked about this same thing. You were going to go see Mr. Clark and get the packet.
Yeah,
I'm going to give
it. But I was trying to avoid it, but I won't be able to qualify for loans. So over this weekend, I'm going to fill out the paperwork and gather all my stuff, and show them proofs of.
All right. Well, Mr. Clark, we're going to go back to you. You need to stay in contact with Mr. Kreitz. If you don't pay that amount of money, you're subject to being evicted on October 6th.
Yes, sir.
That's 10 days from now.
Yes, sir.
Unless you get some funding or Mr. Kreitz agrees to let you stay longer.
Yes, sir.
So keep that in mind. Stay in contact with him.
Yes, sir. I'm taking to the DHS right now.
All right, very good.
Thank you, sir.
Mr. Major, you're kind of in the same boat. You owe a lot of money and you don't have the ability to pay it.
Well, I'm gonna make a payment. I'll make a payment on next week.
Well, the only thing that'll cure this is paying the entire amount. No money judgment is entered at this time. You could be liable for other damages if additional rent is owed. For example, October's rent. When you got divorced, it kind of set you off. Your pins are separated. And yeah, that's what I wrote, which is financially and emotionally struggling. but the arrearage is pretty substantial. I mentioned last week, and again, Mr. Kreitz has got lots of people waiting to rent. But I find this is through September, correct, Mr. Kreitz?
Correct, Your Honor.
The whole month, 3,220. Court costs of 198.40 plus 376. Oops. Is $202.16. If we add that, it gives us $3,422.16. That's a lot. So I would suggest you also take this to DHS. Let's say DHS agrees to give you $2,000. You still would owe $1,400 plus 22. The only curate is paying the entire amount.
Well, if they pay $2,000, I need to pay the rest of it. They give me 1 month.
Well, you
Stay
get
in there
10 days, you get 10 days from today unless he agrees to give you more.
Well, 10 days not enough. 10 days not enough, you know.
Well, he can agree to give you up to 56 days.
Huh?
He can agree to give you up to 56 days. You don't understand the gravity of this. You failed to pay your rent for several months and you're $3,422 behind. The law says unless you pay that entire amount, you're subject to being evicted 10 days from today, which is October 6th.
Well, I'm trying to work things out.
So
I'm trying to work these out.
if he agrees to work things out with you, then that's fine. But if he doesn't, you're subject to being evicted. He can agree to work with you. He has up to 56 days before he asks for the writ of eviction. And it's easier to keep a good tenant in there than to get one in and get another one out.
Well, I've been there several years. It's not like I've been there 6 months.
All right.
I've been there several years, so.
He may be.
I've been there like, what, 8 years?
All right, then it may be worth both of your while to try to get caught up on this. All right, let me repeat. No money judgment is entered at this time. Acceptance of a partial payment will not prevent the writ of eviction. An additional rent will be owed on October 1st. If you do end up moving, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving, which will trigger the security deposit law. I want you to go out to the counter and the clerk will give you a copy of this order. You can take it to DHS. The problem is it takes them a while to process things. I had hoped you would have started this process last week, but you get a copy of this order, take it to DHS. And see if you can get some emergency financial help to stay in your tenancy. The other advice is stay in contact with your landlord. Did you have trouble getting in here today?
Yeah, the cops wouldn't let me in. They're locked.
And yes, the courthouse was on a lockdown.
Why is it locked down? Some criminal here?
What?
Yeah.
Someone had threatened me. And
what was it me?
No, it wasn't you. It was another disgruntled landlord-tenant client. All right, you go out and get a copy of that, and you take that to DHS and stay in contact with Mr. Kreitz.
Did you have to come again in court or not?
No, but you could get evicted on October 6th unless Mr. Kreitz agrees to work with you.
Well, does he want to work with me or not?
Well, you need to go talk to him. All right, you're good to go. Go out to the counter and she'll give you a copy.
I'll be right there to give you a copy.
Okay.
I don't know.
She just was a little bit ago. when
I
tried-
think I have 2 rooms open. I think she's still talking to Keith Cox.
Is it okay for the Hagmans to come in here?
Yes.
Okay.
All right.
All right, thanks.
Thank you. I guess I wasn't gonna say anything about it, but the courthouse is on a lockdown because you're free to go. A previous defendant who was quite agitated here several months ago in a foreclosure, made some threats at that time. They had a very difficult time getting him out of the property. He moved in somewhere else, and there was another termination of tenancy, which he failed to appear for. So he got a default judgment giving him a certain amount of time to move, which is probably about up now. He called the prosecutor's office and made some threats. And so the sheriff's department has the courthouse on a lockdown. I had planned to go out for lunch. Anyway, they're vetting all the people before they can get in here. We've got extra security and sheriff's deputies in the parking lot. And so we certainly can continue to do our Zoom stuff. And Mr. Bush, we're about on schedule. The Hagmans are here. And we'll see them here in a minute.
Sharon, I wasn't having the best audio, so you've done Clark and Major then?
Yes.
I was there, but for some reason I wasn't hearing what was said. I apologize.
I gave them both the amount you had pled and 10 days to move, and told them to get a hold of Mr. Kreitz. Neither one of them seemed to completely understand the dire straits they're in. We mentioned before, Mr. Kreitz has got a big waiting list, although with a tenant like Mr. Major, who's been there for 8 years, maybe it is worthwhile trying to work something out with him, but Mr. Kreitz knows he has the discretion to do that.
I'm not sure why the audio wasn't working, but you're coming in loud and clear now. Thank you, Judge.
We had some problems this morning, which I got turned up. Every day I have a different technical problem. I don't know if it's just me. IT had to help me. My monitor went out, then we got locked out of something. This morning the screen was dark, so we had to shut down and reboot, but we're getting there. I understand the defendants are here. Again, people are having trouble getting into the courthouse because of this additional security.
So Jamie, you're from home then?
I'm back in town, yes, but I'm in my office.
I mean, you're not in the courthouse, obviously. Okay.
No, sir. I really like the Zoom. I hope they continue it. Saves time.
Yes, it does.
All right, Elaine, you can bring the Hagmans in if they've made it in here. When we talked last, all right, Mr. Cox and Ms. Shingledecker are back.
Hello.
Well, we're waiting for the Hagmans. Ms. Shingledecker, I wish we could get that fixed. I'm sorry, it makes you stand up the whole time.
Okay.
All right, let's take up this matter and then we'll come back to Shingledecker. This is Larry Kreitz. Why don't you have a seat right over here?
Okay.
Versus Michael Hageman and Valerie Hageman. They are at 700 West Congress in Sturgis. Mr. Kreitz is their landlord. When we were here last week, they indicated they planned on moving to Tennessee. Is that still correct?
Yes,
Can you be out within 10 days?
yes.
That's the plan.
Yep, we're getting their U-Haul and all that good stuff ready for us.
Mr. Hageman, you're originally from Three Rivers, aren't you?
Yes.
I knew your dad.
Yeah, he's been gone for
Yes, he
20
has.
years now.
He has. He did some tax stuff for me years ago.
Oh, yeah.
And yeah, he's been gone for a while, but I did know him. Mr. Bush, this is filed as a non-payment of rent, substantial rent arrearage. I find that through September, they owe $12,832.50 in rent. $23740 in cost, plus the mailing fee of $376. Total costs are $241.16. So the total is substantial, $13,073.66. I'm not entering a money judgment at this time. Partial payment will not prevent the writ of eviction. The date for the writ is October 6th. There will actually be another month's rent due at that time. All right, now, when you move, the law requires that you give your forwarding address in writing to your landlord and turn in the keys. So you need to stop by Mr. Kreit's office, turn in the keys, let him know your new address, and they can proceed from there. You both got Tiger shirts on. The Tigers are about to give us all a heart attack.
Oh, my goodness. It was a great game last night.
They
though.
did win last night. All right, do you have any questions?
No.
All right, if you go out to the counter, we'll give you a copy of that order.
I do have a question.
Yes.
So right now, the plan is to be able to pick up the truck like on a Saturday. If we're done packing everything up.
If you're out before October, then it won't include October's rent.
No, I'm talking about like on the 4th.
Okay.
And we get everything in there ready, just, we're done, you know.
Yes.
How do we get the keys to them? I don't know where the
what do you want them to do, Mr. Kreitz? Just leave the keys up.
They can just call myself or my father and just leave the keys on the counter, and we'll go pick them up within an hour.
Okay. All right. Best of luck to you. Go out to the counter, you get a copy of this, and then you're good to go.
Okay.
All right, thank you.
Thank you, Your Honor.
All right, Mr. Bush, you got one more. Mr. Schrader is here, but we're going to go back to a general civil case we kind of set aside, and that is entitled Three Rivers Health versus Rebecca Shingledecker. Keith Cox is here. Elaine, can you see what the deal is with that camera in there?
Yes, I sure can.
All right, Mr. Cox, what's our status here?
Yes, we spent a fair amount of time walking through settlement options on the case. I have informed Ms. Shingledecker that I'm going to email her a proposed settlement agreement, conditional dismissal, payment plan, and pocket judgment for her to take a look at. We talked about some numbers and terms, and she wants to take a look at the nature of the agreement and have me send it over. She's also exploring the possibility of a lump sum payment that she doesn't have any means for yet, but it's also contemplating, I think. Plaintiff's position, again, would be that the court does grant the discovery order. I did tell Ms. Shingledecker I would not bother to serve discovery on her as long as we're talking settlement, and maybe in the next 10 days or so, we could work something out. If we don't, then maybe I'd serve the discovery on her. But I think we're on track to getting it resolved, to be honest, Judge. It seemed very encouraging and likely that the parties are going to work it out.
How about if we set a pretrial out about 30 days or so?
In lieu of granting discovery or in addition?
No, I'll grant discovery, but I want to have some target date.
Yeah. I think that's reasonable, Judge. Sure. Can we make it 45?
Sure. Ms. Shingledecker, What I'm proposing to do, I'm going to grant the discovery order requested. You and Mr. Cox have been discussing settlement, and I'm going to set a pretrial for a Monday morning. How about November 17th? Does that work for you, Mr. Cox?
Yeah, it's a good day for the plaintiff, Judge.
Judge Pattison won't be here that day, but I will.
So November 17th, a court date for discovery?
No, for a pretrial. If the matter is resolved before then, you don't need to come. But if it isn't resolved, we'll have a pretrial at 9 a.m. on November 17th. Parties, that's about 50 days from now.
Okay, thank you.
Very good. And Ms. Shingledecker, look for my email probably coming your way in the next half hour or so.
Thank you, Keith.
And you have each other's contact information?
We do, and she'll have mine once I email her, yes.
All right, Ms. Shingledecker, do you have any questions?
Not at this time. Thank you, though.
All right, thank you. You guys can continue to talk, and I hope you can resolve it. But if you can't, we'll discuss it further. He's probably going to hold off on requesting all this discovery while you guys are discussing settlement.
That's right.
All right, you're good to go, Ms. Shingledecker.
Thanks, Judge. Have a good day.
Thank you, Judge.
Thank you. All right, let me finish with Mr. Bush, and then we'll take up our Enchanted Glen matter.
Good morning, John.
Good morning. All right, Mr. Schrader is here. This is Larry Kreitz versus Randy Schrader. Mr. Schrader is here. We discussed this case last week on 9/19. There was an issue about how old this was. Defendant discussed briefly with Megan Bauer. I don't think she actually filed an appearance. Mr. Bush, what's the status here today?
You know, my most recent understanding is that the parties have come together, and he being Mr. Schrader, is going to be paying an additional $200 per month on the arrearage. I'm not sure for what length that's going to be, but that was my understanding.
So are we going to do a conditional order of dismissal or something here?
That's where I think it's going, assuming that's confirmed by Mr. Kreitz and certainly by Mr. Schrader.
Your Honor.
Yes.
When we adjourned last Friday, Jamie said he was going to talk to his dad and then contact me. I haven't heard from him at all.
That is correct, Your Honor. I talked to Mr. Bush, and we just agreed that we would accept his $200 that he offered a month until the $5,079 is paid off. I apologize for not getting with you, Randy.
Yeah, thank you. I do agree to that because I do owe the money, but you know.
Thank you.
Yeah.
$5,729.06 is paid off. All right, Mr. Shingledecker, what we're going to do with this case is conditionally dismiss it based on your agreement to pay an additional $200 per month to maintain this tenancy until the arrearage of $5,729 is paid off. Is that agreeable with you?
I get paid on the second Wednesday of the month, so that's showing that I haven't paid this month yet.
Okay.
I don't think we addressed when he's going to start doing that. We probably should put that on the record, Chairman.
The 15th of each month?
Yes, that would get me past the second Wednesday, because I pay consistently. As soon as I get my check, I go to the Omni and pay it.
Okay, all right, Mr. Bush, could you prepare a conditional order dismissal to that effect?
Yes, we may have turned the numbers around. I believe it's 5,279.06. I'm not sure that was the number that you put on the record, Your Honor.
I wrote down 5729. You got 5279?
Yes, Your Honor.
All right, I must have transposed the numbers last week. That'll take quite a while at $2,400 a year, but it will eventually get it paid off. And he's a good tenant. Mr. Kreitz Sr. wants to keep him as a tenant. He wants to stay there. That's all okay with me.
I've been here since 2011, so it's kind of like, I kind of treat it like my own.
Yeah, you're the kind of tenant a landlord likes to have. And this is an old arrearage they've been carrying, and this is how we'll address it.
And if I do come about some money, I will pay that right off.
Yes, if you win the lotto or you get a big tax refund or something, you can
Or if that
certainly pay.
lawsuit comes through.
Yeah, if that lawsuit.
Yeah, I'm still awaiting settlement.
Yeah. So, who knows? I may die before that's even granted.
Well, let's hope not.
Yeah,
we'll get that conditional dismissal to you, Your Honor.
All right. What year were you born, Mr. Schrader?
I don't know, but I wish I had your hair with my beard. Because it'd look pretty cool. No, I was born in 1964.
All right, Mr. Bush and I got about 10 years on you, so I think you're going to be all right. All right. Good luck, sir.
Thank you very much, Judge, and you have a great day.
All right. Thank you, Mr. Kreitz, Mr. Bush.
Thank you, Your Honor.
Thank you, Jamie. Thank you, Your Honor.
Thanks, John. Go Cubs.
Come next weekend, man.
All right, you'll get a copy of that conditional order of dismissal in the mail within probably by the end of next week, but continue paying your rent.
Oh, yes.
And make that additional payment each month and you should be all right.
Thank you.
Thank you, everybody.
All right. Mr. Kreitz, thank you.
Thank you, Your Honor.
All right, we've cleared the decks, as it turns out, for Enchanted Glen versus Abby Everling. Megan Bauer is here. Abby Everling is here. Daniel Popovitz is here from beautiful Traverse City, and I'm here in Centerville. To make a note.
Good morning, Your Honor.
Good morning.
I don't want to speak for Ms. Bauer, who I know you have who's in your courtroom more often than I, but we have had some fairly, I don't know about productive, but very cordial discussions this morning. And I do not have any tenants here, as you have noticed in the window, because I was meeting with them privately on my own Zoom call, and based on the conversations we had with Ms. Bauer, we've agreed, it was the agreement of Ms. Bauer and I when we left some other confidential conferences regarding this matter that we would ask for further adjournment today of the hearing. We would like to disclose some information from the tenant's file and work with Ms. Bauer to confirm a mutually agreeable amount that may be due for the non-payment, as well as address some other issues that would not be relevant to the non-payment, but are relevant to these parties, and it could be utilize the best efforts of Ms. Bauer and I while we're both involved.
Well, I appreciate that. Ms. Everling, your rent was alleged to be $737 a month. It's the contention of you and your lawyer that rent should have been recalculated in June. And I don't know what that recalculation is going to be. But let's assume it's reduced by a factor of something. Right now, you're not paying, I don't know that you're paying anything. And another month's rent is going to be due in October. They can accept your rent But what I don't want to do is we get to October and I say, oh, by the way, now you owe $3,000 and you're not able to pay it. So whatever money you've got, make sure you set aside September and October's rent. We'll see what it is, but there's late fees in here. There's some other things. We're going to try to sort it all out. Your lawyers have been working hard on this all morning, but we haven't gotten to where we need to be. How long of an adjournment do you request? No matter what we do, we're going to be into October.
Right. I'd ask 2 weeks at least. I just think time goes so quick, and I think Ms. Bauer and I can work together really well, but just 2 weeks seems at least the minimum.
And you got to crunch a bunch of numbers and you got to share it with your people. So 2 weeks from today would be October the 10th. So let's see what we got for time for that day. I got Mr. Reed in there. How about 11 o'clock? Boy, I haven't even filled it up yet. 11 o'clock on Friday, October 10th. Does that work?
I'll make sure it does, Your Honor.
Yes, Judge.
All right, these other issues you alluded to, are they, and I don't want you to get into details, but are they lease violation issues?
Yeah, Your Honor, I'll be very careful with my wording because I don't want to create any misperception. But yeah, I think there's the recertification arguments that Ms. Bauer brought up at the first hearing that you've alluded to as to the amount of rent that's due and owing. There are some other things that are taking place that have been brought to my attention. And I always find it to be tremendously beneficial if a tenant has legal representation through legal aid or otherwise. And I think we have a good voice piece with Ms. Bauer to sort of address some of those and maybe not only resolve the non-payment, make sure we're on the same page as to the amount of rent moving forward in the recertification processes as they may be, as well as other obligations of either party going forward and avoid future filings or notices as a result.
I think that's wise. What we're alluding to, Ms. Everling, and I don't know that anything's, I'll take an example. Let's say that your lease says you're not supposed to have a dog and you've got a dog in there. This is a theoretical. And so even if you pay your rent, your landlord may ask to terminate your rent because you're violating the lease by having a dog. So Mr. Popovits has alluded that there may be some sort of lease issues, and his theory, which I agree with, as long as you got counsel, they're going to work on everything. If there are other issues that maybe are non-compliant with the lease and some amount of unpaid rent, they're going to work on all those issues. So you would win the battle but lose the war. If, let's say, I reduce your rent to $200, then they move to terminate your tenancy because there's lease violations. So it is wise to try to address everything. So we will adjourn.
May I just add to the record that if we are truly going to try to address everything, then my client will be keeping family status, which is a protected class, family status-based discrimination on the table in our conversation. I'll leave it at that. I'm aware of some of the non-rent related concerns involved in this case. And as my colleague states, ideally we'll be able to work towards a resolution to avoid having multiple cases and extended litigation. But it does cut both ways, perhaps, at this point.
All right. Very good. Ms. Everling, you've got legal counsel, which means you're way ahead of where a lot of people are. You've got your lawyer and their lawyer working on trying to work out a resolution, which means generally maintain your tenancy. So we'll address this at 11 o'clock on October 10th. I'll
Judge,
see everybody.
Can I ask one additional question of the court?
Yes.
Will the court treat this hearing in 2 weeks as a pretrial, or would the court expect us to be in person for a contested?
No, you will do it by Zoom. If it is contested, I'll block out the rest, block out till noon.
Your Honor, also.
But everybody may appear by Zoom.
Thank you for that courtesy. Appreciated.
I guess I'm not sure that the parties are entirely clear on all layers of what is contested. The regulations, the parties are not even on the same page on which regulations control this tenancy at this point. So I'm a little bit.
Right now, it's just a non-payment of rent case. And I got your appearance about a second ago and your brief. So I haven't looked at it carefully, but right now I'm just trying to figure out a number that I'm gonna tell her she needs to pay.
And how we calculate that number depends on whether we're under the rules of the Department of Housing and Urban Development or we're under the rules of the U.S. Department of Agriculture. And right now the parties aren't on the same page on that.
All right, well, I love getting into federal regulations and arcane minutia regarding these federally subsidized leases, but we'll see how much progress we can make on October 10th at 11 o'clock.
Okay.
All right, thank you.
Thank you, Judge.
Thank you, Your Honor.
Thank you for your patience.
All right, Ms. Evans, I'll see you in 2 weeks.
Thank you, Your Honor. Everyone have a good weekend.
You too.
We're working on it. Thank you.
Judge, that concludes the landlord-tenant docket this morning then?
Yes, it does. Thanks.
Thank you.
Would lock big if they found him? All right. Apparently the courthouse lockdown has been lifted. They found the person that is very angry. And we'll see where that goes. I've got to go in that room and work on that camera. That is stressful to the staff when that sort of stuff happens. But apparently he's in custody. So everybody is breathing a little easier. You'll recognize him when we get into the case further. All right, that finishes our morning. I do have at least one bench.
Court is on the record in State of Ohio versus Destiny Joe Barker. Case numbers 25 CRA 276 and 25 CRB 277. In these two cases, Ms. Barker pled not guilty on September 18th, 2025 to a 5th-degree felony charge of aggravated possession of drugs and to a 1st-degree misdemeanor charge of attempted aggravated possession of drugs in these cases respectively. And these cases are set today for a preliminary hearing and pre-trial conference. Court is also taking up City of Conneaut and State of Ohio versus Destiny Barker, 25 CRB 116, 25 CRB 115, and 24 CRB 246. In these cases, probation violation complaints were filed against Ms. Barker. On June 24th, 2025, warrants were issued. She was arrested on those outstanding warrants on September 18th, 2025. And at a preliminary revocation hearing on September 18th, she pled not guilty to the complaints filed against her. These cases are set today for a final revocation hearing. Ms. Barker is currently incarcerated on the probation cases, where I set bond in the amount of $10,000, cash surety 10% in each case. So she has not been able to post bond in those probation violation cases, and she is appearing at these hearings by way of video from the Conneaut City Jail. Her attorney, Sean Martin, is in the courtroom. He is appearing at table 1 on the video. Also in the courtroom is Law Director John Lewis and Probation Officer Sean Benoit, and they are appearing at table 2 on the video. This hearing is being recorded utilizing whereby.com. Mr. Lewis, can you advise them to the status?
Thank you, Your Honor. The offer that was extended to Ms. Barker on the 2 pending cases, the CRA 276 and CRB 277, the state of Ohio will dismiss the CRA 276 case at Ms. Barker's cost. With that dismissal, the offer is to plead to the CRB 277 case, the attempted aggravated possession of drugs, misdemeanor of first degree. With that, the state would recommend probation, whatever fine the court would deem appropriate, along with the court costs of the case. And we also discussed the possibility of Ms. Barker going back into removal court. As far as the probation violation cases, Your Honor, the offer is to plead to the admits to the violations, and with that, the parties would then argue sentence. Thank you.
Thank you. Mr. Martin?
Yes, Your Honor, thank you. Your Honor, if the court were to accept the offer as proposed before it, Ms. Barker would be willing to withdraw the prior pleas not guilty and or plead guilty to the 277 count, and then be prepared to admit to the violations in 25 CRB 115, 116, and 24 CRB 246. Thank you.
Thank you. Okay, Ms. Barker, it's my understanding today that you wish to enter guilty pleas to the first-degree misdemeanor charge of attempted aggravated possession of drugs in 25 CRB 277, as well as admit or plead guilty to all 3 of the probation violation complaints filed against you in 25 CRB 115, 116, and 24 CRB 246. In exchange for those guilty pleas, the felony charge of aggravated possession of drugs would be dismissed at your cost. Is that what you would like to see happen today?
Yes.
You understand by pleading guilty to these charges and complaints, to this charge and complaints, that you are waiving your right to a trial, as well as a final revocation hearing, which means you'd be waiving your right to cross-examine witnesses and to confront evidence presented against you. You'd be waiving your right to testify or not to testify without any negative connotation. In the new criminal charge, you would be waiving your right to be proven guilty beyond a reasonable doubt. And in the probation cases, you'd be waiving your right to be proven guilty by a preponderance of the evidence. You'd be waiving your right to subpoena witnesses. In the new case, criminal case, you'd be waiving your right to a jury trial. All of those are trial rights you'd be waiving, and hearing rights you'd be waiving by pleading guilty to the new charge and to the complaints filed against you. Is that what you wish to do today?
Yes.
You are represented by Mr. Martin. Have you had sufficient time to consult with him, and are you satisfied with his counsel?
Yes.
Are you currently under the influence of any drugs, alcohol, or prescription medications that might affect your thinking?
No.
Are you currently on probation, parole, community control, or post-release control with any court other than Conneaut?
No.
Has anyone made any promises to you about what your sentence will be in order to induce you to plead guilty to the new charge, as well as to admit to the probation violation complaints filed against you?
No.
And are you thinking clearly and do you understand everything that's happening?
Yes.
Okay, I'm going to ask the corrections officer to provide you 4 documents. 1 Form 3 and 3 Form 5s. And bear with me, I'm going to provide Mr. Martin the same documents in a minute here. Do not sign anything until Mr. Martin advises you. I'm going to ask the corrections officer to scratch off on all of the Form 5s, to scratch off paragraphs 4 and 5.
Destiny, can you hear me? Okay, when you look at the forms here, the first one you're gonna see, it should be the waiver of your trial rights. Do you see that?
Yes.
Okay. This is, it says here, State of Ohio versus Destiny Barker, and it's stating that you under one, it understands that you have a constitutional right to a trial by jury, okay? And that by pleading guilty, you're waiving that right, okay? Number 2 is that you have a right to a trial, and at that trial, you can cross-examine witnesses. I would be there to help you, but we would cross-examine witnesses. We could present our own witnesses and evidence. Okay, well, I'm saying you would have that right at trial, okay? Do you understand that?
Yeah.
We're not saying we're gonna do that, I'm just telling you that's a right you have, okay? And the prosecutor has to prove your case beyond a reasonable doubt. If you plead guilty, you're waiving that right. Do you understand?
Yes.
Okay. Number 3, you have the right to testify on your own behalf. You can't be forced to, all right? And if you decided to remain silent, nobody can hold that against you if we were at trial. Remember, we're not going to trial. It's just that's the right you have, okay? Does that make sense?
Yes.
Okay. So you're waiving that right as well.
Yeah.
Number 4 says you understand that the plea of guilty is a complete admission of guilt, okay? So that's why by pleading guilty, you're saying, yes, I did it, I did the whole thing.
Yeah.
Okay. Number 5 doesn't apply to you because we're not pleading no contest, okay? So we're gonna skip that one for now. Do you have any questions about that?
No.
Okay, if everything seems fine, go ahead and sign where it says the line for you to sign on. And I'll sign this one here. All right, Jesse, when you're done, let me know, okay?
I'm done.
Okay, so the next ones, there's 3 of them, they're gonna be the same thing, okay? It says waiver of hearing rights. Do you see that?
Yes.
Okay, so you have 3 separate cases, but they're all the exact same form. If you want to read all of them on your own, we can do that. But I'm just going to go through one right now. All right? It says that, you know, once again, it's got your name on it. It says, I have the right to a preliminary hearing and final probation hearing, okay? Remember, like I said, you could force them to come in and prove that you violated probation, okay? I know you're not going to, but you have that right to do so, okay? At that hearing, we would confront their witnesses and evidence. So obviously, some of their evidence would have been Officer Benoit, but also the people from New Beginnings would come in and say, yeah, she's not here, and she left, okay? We would have the right to process-examine them. We could bring in our own witnesses to show if we were gonna contest it, okay? And then at that hearing, you also have the right to testify if you wanted to. But you don't have to, and nobody could force you to testify, okay? So just like a trial. The number 4, you have the right to an attorney. I am here right now for that, but we're not, you know, we're not looking to continue this. We're looking, you said you wanted to plea out today, okay? And then number 5, it's X out, but since you can't afford an attorney, I was going to represent you, okay? Does all that make sense?
Yes.
Do you still want to go forward with this and waive your preliminary hearing and admit?
Yes.
Okay, if you want to do that, go ahead and sign there. You're going to sign each one.
And it's 9:24.
All the waivers are signed, Your Honor.
Thank you. Okay, the court does find that the defendant and her attorney have executed in open court the written waivers. Court does find the defendant's pleas of guilty admissions to be knowing, voluntary, and intelligent. Court will accept the guilty pleas and admissions, and I will therefore find her guilty of attempted aggravated possession of drugs, a first-degree misdemeanor, 25 CRB 277, and of having violated the terms of her probation in 25 CRB 115, 116, and 24 CRB 246. I will dismiss at the defendant's cost the felony charge of aggravated possession of drugs in 25 CRA 276. We will now proceed to sentencing. Mr. Martin, is there anything you or your client would like to say in mitigation of?
Yes, Your Honor, thank you. Your Honor, I think it's probably fair to address these all together because I think they are very clearly all related.
Yeah.
For Ms. Barker, we were here before on the 115 and 116 case. When I first started, when I first met Destiny, you know, she was clearly in the middle of her addiction. And at that time, the court allowed her to petition to join renewal court. So my understanding, she was accepted, but then she did leave. And in addition to leaving there, she also did leave New Beginnings. I've talked to her a little bit about that, and it does appear for her, it's, from her position, it was overwhelming, I guess, everything going on. But at the end of the day, when you don't have any structure and there's not a lot of, you know, you're kind of rudderless, this probably would feel very much like a lot to take in all at once and a lot to do. But as I explained to her, it's really not. It's just helping you get your life on track. And if it does feel like it's too much, you can talk to them, tell them, hey, I feel like I'm overwhelmed. What can we do? Like, can we, and there's work and there's opportunity and it can be talked about. It can be discussed. That's the way you address this. It's not just upping and leaving and then now you're back in front of the court again, not with probation violations, but also, again, caught with drugs and again, caught in the same situation you were in before renewal court even started. So, Your Honor, for her, I mean, this is somebody who's seriously, you know, it's, I think she's struggling to address the matters here, and I think she didn't fully appreciate or understand the options available. I think you even said it at the last hearing. The court wants to help her. And the court in general, but also the probation department, everybody wants her to be better. I want to be able to see her a year from now, walking down the street, and you could say like, you know, a 100% different situation. And I think she can do it. I think for her, I think just understanding that recovery is not an easy thing. It's not merely just sitting there and things get better. That there's work, and there's a lot of work, and it's hard work. And I think she understands that it's gonna have to happen, the hard work needs to happen, and yeah, it may feel overwhelming, but that's because you do things that are, you know, we don't do them because they're easy, we do them because they're hard. The easy thing is to sit there and just keep using drugs. The hard thing is recovery. I think she understands that now. I've talked a little bit about that. And with that said, Your Honor, I know she was already in recovery court once, but we would ask if you would allow her to, the opportunity to get back into recovery court. I know it was only a brief time, but we'd ask the court to indulge that and allow her the opportunity again. And with that, we'd also ask for probation on the offense. We'd ask for no more jail time. It's, I know she's only been in for a couple of days, but I know it's probably felt like a lot longer from having to sit here. Thank you.
Thank you. Ms. Barker, is there anything you would like to say before I impose sentence?
I'm sorry, I shouldn't have. And I appreciate it. And I wish I would have stayed, and yeah. I'm ready.
Mr. Lewis.
Thank you, Your Honor. The incident that gave rise to this attempted possession, aggravated possession of drugs charge happened on April 30th this year, same time as the possessing drug abuse incidents that she's already stands convicted of. She was found sleeping on the sidewalk at the State Street McDonald's. Officers approached her, determined who she was and that she had warrants for her arrest. She was taken into custody, found to be in possession of several syringes and 0.81 gram of methamphetamine. I hope that she will, if she is admitted in juvenile court, she will take advantage of it this time and be successful in recovery and getting her life on track. I would ask that she would be held in custody, and if the court is amenable to an assessment for the real court, et cetera, that she would be kept in custody at least until such time as her assessments have been done and a determination has been made whether or not she's going to be admitted. Thank you.
Thank you. Officer Benoit.
Your Honor, I would just remind the court that these probation violations stem from her leaving a residential treatment facility for the second time, leaving the first time on May 17th of 2025. In this instance here on June 23rd, 2025. While Ms. Barker was incarcerated down in the County City Jail, we did conduct a urine drug screen on the 19th of this month. She failed for methamphetamine and amphetamine.
Thank you. So Ms. Barker, I'm going to ask you some questions. So step forward so I can see you. So Ms. Barker, you're 24 years old, and I want to know whether you have any interest in getting well.
I do.
You know what?
I do.
Is your, listen to me. Is your interest simply to get out of jail so you can escape again and leave? Is that your interest, Ms. Barker?
No. No. I want to get on medicine now, and I want to get on medicine to try to be on that road. I want to get my life together. I always have, and I thought that I could do it faster on my own, but I proved when I was out there on the streets and I was living in a tenement, and I got a job at this mod car wash, but I was still using, and I couldn't juggle both, and I just know, like, I need to take the time to get my mental better. Do the right steps instead of trying to be so freaking impatient or whatever it is that I am. But I have so much guilt and much and I don't know how to switch it to, so I've just been using for as long as since I lost my kids. And I've been mine. And I got so many goals and aspirations for my life. I want to, but I have no one.
So Ms. Barker, I just want to, can you answer this question for me? Is there something going on there?
No, one's told me.
Can you hear me?
Yeah, I'm sorry.
Your Honor.
Okay. Ms. Barker, can you answer this one question for me? Why do you continually refuse or fail to accept the help that people are willing to give you so you can achieve your goals, so that you can start living a productive life? Why do you continue to refuse the help that we offer you?
In my brain, I think I wanted to do it on my own so I could go back to my family, to my grandma, and say, a lot of baggage with my family stuff, but I just wanted to say, hey, yeah, I got in this issue, and then I pulled myself out of it, but I can't pull myself out of it. I haven't been able to, not at all. I just keep getting dragged back into.
There are a lot of people out there who would really die for the help that's being offered to them through our program. The way they show their gratitude and appreciation with all of the resources and help that we provide is they do what they're told to do. And when you don't do what you're told to do, not only are you violating the court order, but you're just refusing the help that people are offering you to get well. And so you've done it twice already. Assure me that it's not going to happen again. Instead of
Judge Arochi, please, from the bottom of my heart, please give me one more chance. I swear, I will do what is I don't want to be cheesy and say destined for my life, but I will accept the help and I will try my hardest. And yeah, I know I've been a lot.
Well, I did receive the application that's been approved for renewal court, and that would be in the new case. But she's been effectively terminated from renewal court, but there won't be any new assessments needed for her. It hasn't been that terribly long to get her back. New Beginnings has beds, right?
Yes, Rob.
Look, Ms. Barker, I'm not messing around. You've sat in this courtroom across from me within 3 feet from me during renewal court meetings. And so I'm not messing around. I'm going to tell you this one last time. 3 strikes and you're out. Right now, you've got 2. 3 strikes and you're out. I'm not messing with you. You're 24 years old. We're giving you a chance to change your life for the good, because all of your life has not been so good. So we're going to help you change it. And again, we're going to offer the resources. And if you refuse it one more time, if you do anything to violate the conditions of your probation and your sentence and renewal court, I'll terminate you, and then you'll go to jail for as long as I can put you there. You understood?
Yeah,
Yeah.
thank you.
Okay. On the, I'm going to sentence on the criminal case first, 25 CRB 277, 180 days of GLR suspended, 3 years of supervised community control, no criminal offense for 3 years, $250 fine and court costs to be paid no later through payment or through community work service no later than December 31st, 2026. She's ordered to successfully continue her treatment at the Lake Area Recovery Center and Community Counseling Center. If they require an assessment, so be it. But that'll be for substance abuse and mental health purposes. She's to comply with any recommended course of treatment, execute any necessary releases for probation to monitor. She's not to purchase, possess, or consume any alcoholic beverage, a drug of abuse, or any pseudoephedrine product, or go into any bar or liquor establishment for a period of 3 years, and she must successfully participate in and complete renewal court as a condition of her sentence. This sentence is concurrent to all other sentences. 25 CRB 116, 25 CRB 115, 24 CRB 246. She will be given 6 days of jail credit from the date of her arrest on September 18th until today's date. Any objection to that jail credit?
No, Your Honor.
No, Your Honor.
Okay. As she's being held on all 3 cases, she'll be receiving a jail credit in each case. Are we able to transport her today, or is it?
I can transport today, yes, Your Honor.
Okay. She will be released to New Beginnings, back to New Beginnings today. So that means 72 days of jail will be suspended in 25 CRB 116. 162 days will be suspended in 25 CRB 115. And 492 days will be suspended in 24 CRB 246. I'm extending her probation in each of those cases for an additional year. With all of the same conditions, again, with renewal court, she's ordered to successfully participate in and complete renewal court and do all the things that I've just essentially said as part of the sentence, as part of her previous sentence and as part of the new sentence, which means her treatment at New Beginnings, Lake Area Recovery Center, and Community Counseling Center. You do have a right to appeal. You have a right to appeal without cost. You have a right to have counsel appointed on appeal without cost. You have a right to have documents provided you necessary to file an appeal without cost, and you have a right to have a notice of appeal timely filed on your behalf. Is there anything further, Mr. Lewis?
No, Your Honor.
Mr. Martin?
No, Your Honor, thank you.
Okay. Officer Benoit?
No, Your Honor, thank you.
Okay. One more chance. Got it?
Yes.
Okay. This matter is concluded. Thank you. Thank you, officer.